Honorable the Deputy Speaker.
Yes, as we resume, the member for St. Augustine, you have an additional 7 minutes, 37 seconds of your initial 30 minutes, and then you have an additional 15. Do you care to avail yourself one time?
I'll be most grateful.
So kindly proceed.
Thank you so much. Before we took the break, Mr. Speaker, we had dealt with the issue of the submissions of the learned leader of the opposition, where Section 67 and so had been struck down by Madam Justice Pemberton. And we were making the point, and I think it needs to be remade, that it is wrong at this time for the Attorney General to attempt amendments of a section that has been struck down. The Court of Appeal, of course, having ruled on the matter is now to be entertained before the Privy Council, and it would be wise and the right thing to do for the Attorney General to hold his hand until, I believe, the Privy Council makes its final determination on this matter. Now, Mr. Speaker, we are dealing here to put us back in the perspective of a person's right to choose whether they wish to be tried by jury or by judge alone. On that basis alone, I wanted up front to say that as a practitioner and having spoken to many of my colleagues in the profession, I believe that this law will take us nowhere. Who will choose a judge to make a final determination both on facts and on law as to the innocence or guilt? On what basis do you do these things? What confidence now resides in the judiciary as a whole to make one believe that you will be the beneficiary of a fair trial by a single person? I pause. What gives us the confidence in our judiciary to make one believe that they would be the beneficiary of a fair trial by a single judge? When one looks at the composition, thank you very much, Mr. Speaker, of the Supreme Court, and in particular the criminal branch, I ask the Attorney General to tell this nation how many of our judges came from the DPP's department. I pause again. How many of our judges in the criminal division came from the DPP's department? My understanding, and for what I've been told, it is the largest percentage of persons who came from the DPP's department who have been ultimately elevated to judicial high office of being a judge of our Supreme Court. I congratulate them because it is a career path that they had chosen. Many straight out of law school into DPP's department, serving the nation as best as they could, and then ultimately either becoming a magistrate, congratulations, or a judge, congratulations again. But remember where I had started earlier about the biases to which we are all victim, because we are creatures of our circumstances from our birth onwards. And I want to say that a person who has a choice to make between having his matter heard before a judge whose only professional experience has been as a prosecutor and then as a judge, which one will you make? Would you put it in the hands of that person whose entire professional experience, practice, instincts developed over sometimes years, because they have to be at least 10 years at the bar to be a judge? Would you choose that person over members of our community with their collective wisdom and judgment? And therefore, the optimism that my friends have, it is good to have hope, but it must be grounded in reality and rationality. And I dare say proportionality. It lacks in all of those marks, and therefore I do not share the optimism that this will take our workload and the judicial pace any much faster. While I'm on the topic, Mr. Speaker, it is very important to also note that historically, as I've given one example in the civil courts, I've given another example in the criminal court where the judge spoke with his body language so much louder than any written word could convey. There's another example I wish to bring to your attention. There was a particular judge who had a penchant for wanting to pass rope, as we say. Pasha, I didn't want to mispronounce it. And he took almost a perverse pleasure in guilty verdicts when they were rendered. And there was a case, I was still a student, when 5 young gentlemen who had never had any previous convictions, no problem with the law, had been charged for and convicted of a murder. 5 brothers. And there I was, with an innocent eye and a warm heart, feeling the anguish that there it was, 5 young lives now being put to a death sentence. The judge had tears in his eyes, and I thought he was actually weeping out of sadness, only later to learn it were really tears of some perverse satisfaction. It really happened. And this very judge, as I say, never liked lawyers who would really put up a fight for their clients. And I give you not just an opinion, but I'll give you facts upon which you will form your own. In the old days, legal aid was what, $1,100? Marlene, you remember? Yeah. You will do a case for 6 weeks, which is an extensive case, with sometimes 4 and 5 accused persons. And at the most you will get, that was the judge's limit, they have to sign off how much you get, $1,100. I'm not boasting, but I will do every case whether I got $1 million for it or one, as if it was the most important case of my life. And I did a trial before this judge who was being extremely difficult for the defense. At the end of which, I think it was about 3 weeks, the jury acquitted. And the judge certified fees fit for counsel for 3 weeks, $480. Insultive, I put that 20 and deposited. I couldn't deposit less than 500. 2 weeks after, there was a client, of course, legal aid, who had previous convictions and had been serving time, and the opportunity arose for a guilty plea. It was a case that we could have fought, could have won, but the accused said, look, I'm serving time in any event, take the plea. Half hours work in the morning, certification, $960. What was the message? Fight for 3 weeks, 480. Plead guilty, 960. Clear. And that is one example I also will remember. There are judges who were in the habit of threatening contempt of court. Whenever you were about to really open up a prosecution's case, something or the other, they will make an objection, and when you respond in a way, you will be threatened, the book will come out, contempt of court, and will be flashed before you. You heard the leader of the opposition speak about note-taking, and the Attorney General, as I experienced, very good civil lawyer will tell you in his cross-examination, there will be moments when you build up to that one moment where the answer will come and your case will be won, properly timed. And guess what? As you're about to pull, as we say, the trigger, the judge will say, hold, hold. I didn't get that. Repeat your question. Pause. Time it. And the moment sometimes will be lost. These are the experiences of the court. Coming back to modern day. How could we have any comfort whatsoever that a judge alone trial is fairer than that with a jury? when one from the DPP's office, a man who I had known and respected when he first joined, but my respect for him grew immensely when he put a complaint in a case that the trial judge, he's a prosecutor, let me underline that the trial judge will call in the prosecutors in the case upon which she sat, my lady, a high, almost sacred office, and tell the prosecutors what to do next. This happened, I'm not talking 10 years, 20 years ago, I'm talking within the last 5. A most senior of our criminal judges calling in the prosecution and telling them what to do next, how to deal with issues, orchestrating how the case proceeds.
Honorable Member, I'm trying to understand your point, but you're not calling names, but you're insinuating, certain references as you go along. So please, let's stay away from that angle. Proceed, but let's not go into the angle of where you are actually saying what the judges did, even though you're not calling names. Proceed.
I will call a name. Yeah. Not the judge's name, the prosecutor's name as a matter of public record. Brent Winters.
Member, again, I know you have that prerogative to do, but please, let's don't go down that road.
With all due respect, Mr. Speaker, this is where we must go down the road.
Which road?
Yes.
I am not one to walk my client down death row, I'm not one. And I came up with a statement over the years that courtesy kills clients. There are lawyers who will, in satisfaction to a judge's smile and supposed pleasure, not fight for their client as they will. This is a people's parliament, and I understand the sensitivity. But if these things are not spoken, then we have an artificial world out there. And while we're on that topic, some months ago, the member for Naparima was speaking, and he spoke of his age, having arrived at a ripe age. A landmark. And he said why he had to speak that way, because his time now, he knows, is a countdown. And therefore, every moment matters, and every word in the sacred place must carry value. And others denigrated it. They didn't quite understand that when you reach a point in your life, you realize what is really important is a change you can make of a positive nature to benefit your country. And that when you speak these things, sometimes you have to put aside, I have to go back to court. I do, but I'm unafraid. I'm unafraid. Because if we do not speak these things here, then the wrongs that occur out there will continue undercover. When we had a meeting, this is in high public glare, of the Chief Justice recently calling a meeting to try and sort out this sordid affair with the resignation of a High Court judge who was Chief Magistrate. It is reported that one of the judges says, send me down there, I'll deal with it in half hour. Deal with what in half hour? This thing about speedy trial is important, yes. But when you rush the brush. Right? Less speed, wrong haste. I don't know. What is the statement? What is the statement? Right? Hungry dog eat raw meat. I'm hearing that. Thank you.
What a Spain so.
These are fundamental issues that we cannot sacrifice at the altar of expediency, the very justice system that we need to protect. And having heard what is coming down the barrel of this gun, because let me tell you, this is a little, what they call, testing the water a bit. A little slip. Give you a right to choice to get rid of jury trial. We will get acclimatized. And as the member for Chaguanas, West has told us about the boiling crapo, which I use all the time. Our crapo will be cooked very soon if we don't watch what is happening. If we don't watch what is happening. Because the very tenor of the contributions thus far tells us that they want to get rid of jury trials. And we've been regaled by Professor this, Chief Justice that, But you know who the largest majority of those who call for the removal of jury trials are? Judges and former judges. Power has this capacity to seduce you to have more power. And power despises other power. The balance in our system of justice, where I had said before, is where the jury, our peers, our fellow brothers and sisters who have life experiences, balances off each other's biases. Sometimes they may not always get it right. But if we remove that possibility, then you will be left with the bias of one. And in our present circumstances, not knowing how they are chosen, who they are, what their history has been, what are we doing? Where no one trusts anything in the society. Some of the very good works attempted by my learned friends in their ministerial positions sometimes are attacked with from those who do not know exactly the truth. But we do not have anymore in this country a presumption of innocence. Those are just words. In this country, everyone is presumed guilty until you prove that you're not. Yes, even in our courts, when you see the contempt that are held, that accused persons are held to by prosecutors, sometimes the very judicial officers. And unless you are very good or you have, what shall I say, the facts that are properly harnessed on your behalf, it is very easy for the innocent in an environment of increased crime for many of us to believe that we have almost a sacred duty to convict those who are before us. And we have to be really, really careful about that. I did a trial last year. 2 policemen charged. And this judge, I shan't call her name, when finished summing up the case, not a mention of the cross-examination or damage that was done to the prosecution's evidence. And I had to rise and say, what are you doing? Where is the case on behalf of the defense?
Standing order 48-1, please.
Member for St. Augustine. Member for St. Augustine, I've given you twice on 2 occasions, I would have mentioned it to you. This is the 3rd time. Please desist and move on. Please
Absolutely.
desist and move on.
Yes. The jury acquitted.
Mr. Deputy Speaker, I also rise on 48-8. Even though he's not calling the name of the judge, he is breaching 48-8.
Again, member, move on.
How many? In total? Oh. So, I would like for the Attorney General, because I've grown to admire his approach in terms of a scientific, yes, in terms of statistics and so. If we are to, in a way, blame jury for delays, how many convictions in our criminal courts by jury trial, where a judge sums up a case, have been overturned on appeal? Let us fix those things, because let me tell you, it has nothing to do with the jury's finding by itself. It has everything to do with the judge's summation of the evidence in the case and the law applicable. Member for Laventille West, you know this, you are a practitioner. There were many, many, many of the convictions that are overturned and sometimes very basic errors of judges. It is a complaint not to denigrate, but it's a complaint that these are the things that we can fix. So that when you have a conviction, member for Port of Spain South, really a guilty person properly convicted, it should not be overturned on the error on law of a judge. The jury's function is to hear the evidence and determine if they believe beyond a reasonable doubt the prosecution's case. If there is a doubt, they will acquit. If there is no doubt, beyond a reasonable doubt at least, the evidence is satisfactory to them, they will convict. So that is their reasoning. But the judge's summations are sometimes very subject fatal errors. And we need to fix those. Those are fixable things. And I know a lot of progress has been made under our present Chief Justice to fix those things. I must congratulate him for those efforts. So to suggest that the panacea, thank you very much, the panacea is to be rid of the problems, quote unquote, and paint a dog as guilty and hang him, and now we do so with the jury and suggest they are the reason for the days. Not at all. We really do need more judges who are more focused and to ensure that when they sum up a case, there is no error in law, an application of law, so that we do not have repeat matters. And many of the cases were sent back for retrials, and retrials are even longer than the first trials. Member for Port of Spain, North St. Anne's, you know this, because you have much more volume of documents to go through. You have your preliminary inquiry, evidence of the first trial, and then you have the evidence again. So they're much longer and more cumbersome. And we must fix those things, and rightly, the issue of recording in court. That's a must do, because very often the judges really miss out on most of the evidence in terms of the facial expressions, the body language of the witness when they give it, because they are duty bound to have proper notes. And these are the things we really should provide. So, Mr. Speaker, I want to thank you for this great opportunity and to warn this nation, all of us, that we must not be seduced with what appears to be patches and quick fixes to matters when the fundamental problems are not fixed. And the fundamental problem to me in relation to all of this is rebuilding the confidence in our judiciary, which is at an all-time low. Do not now put on it the possibility of further attacks, because when a person chooses, I say I want to go by judge alone. This is a country that is riveted by rumor, suspicion, and a host of other unsavory things. That you choose to go by judge alone because you fix it. Money pass. Why would you choose a judge as against a jury? So that...
Remember, your time has expired.
Thank you very much.
I recognize the member for Laventille West.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, in all earnest, in all sincerity, I have listened to the presentation of my friend, the member for St. Augustine, and of course, had the opportunity, that's the most neutral term I could use, to listen painstakingly to the member for Siparia. And in this house so far, I have come to the conclusion in all earnest that they really have no issue with the measures that the Attorney General put before us here today. Really. The member for St. Augustine spent considerable time and had to be upbraided in some ways and cautioned about his personal professional experiences. I want to say two things. I practiced for 20 years at the criminal bar and in the civil courts as well. And a lot of what you heard from the member has not been my experience.
Magistrates court lawyer.
Yes, yes, so he says. So he says. But I practice in the
Members,
high court.
Again, we are going pretty fine. Let's don't have the necessary interruptions. Proceed, member.
Practice in the magistrates court, extensively in the high court, and extensively in the court of appeal as well, with a tremendous record. But that has not been my experience. Not that magistrates can't be a little quirky sometimes, and judges too. We are all humans, and yes, I've experienced that. But the extent to which my friend has gone, I'll tell you this. The other thing I want to say, the members said categorically that judges are not necessarily unbiased. Well, of course, they are human beings and they would have. But you see, Mr. Deputy Speaker, confidence, my friend ended on the issue of confidence in judges and confidence in the judiciary. Only very recently, there was an uproar in the society when persons formed the view that some of my friends in opposition to us in this parliament, who are practicing attorneys outside, must have, listen to me carefully, it appeared to members of the public that they wrongly, that they thought that they had friends in the judiciary to the point where they were judge shopping. And that caused consternation in the society and affected confidence.
Speaker 48-8.
Members, again, member for Laventille West, let's tread carefully along the path where we're going into mentioning the judges and so on. I know you all are not calling names, but let's be careful based on Standing Order 48. Proceed.
Let the record read, I cast no aspersion on any judge. I said the public felt that my friends who were taking certain matters to court all over the night, that they believed...
Member, you do not need to repeat what you said. Kindly move on.
Thank you.
And members on the other side, again, the supportive suggestions. Not today, please. Proceed.
Thank you. And I want to say one more thing. In light of the fact that the member for St. Augustine gave us a whole panoply of his personal experiences, there are two sides to the story, you know. We have to wonder how the judges were looking at him. What they were thinking about him. They have their story too. But that is another
Deputy
matter.
Speaker 48-6.
Again, member, let's move on.
Thank you very much. Mr. Deputy Speaker, the Ireland experience was as follows, and I lived in England and studied there at the time of the IRA bombings of London and all over Manchester, all over England. I lived with that myself. Felt uncomfortable standing next to waste paper bins in the train station and so on, because it happened regularly. They were bombing train stations and wherever they could. And the issue with the so-called Diplock court, it was Lord Diplock who had adumbrated, if you like, the whole idea of a judge alone court in Ireland, because the facts from scientific analysis of those facts revealed that when cases against IRA suspects came before the courts of Ireland, the people in Ireland who were largely supporting this activity insofar as the politics of it was concerned, they would listen to the evidence, and there were many occasions when the evidence was clear and straightforward and there were what we call perverse verdicts. The jury found not guilty against the grain of the evidence. And that was the problem that Britain faced. And that is what led them to come into a position where they will remove the jury and it will be heard by a judge alone. It was a response to a certain set of circumstances. So when my friend from St. Augustine spoke about jury would find this and that, the Diplock courts in Ireland was testimony to the fact that juries, much as he lauds the jury, could hear evidence and give verdicts completely and diametrically opposed to the grain and the trend of the evidence. And so it is. Systems of justice are never perfect. Never perfect. So let me press on. The member for St. Augustine defended and supported the members for Separia in her position, in her submission here, that Section 67 and Section 68 of the Offences Against the Persons Act 1925 were found to be unconstitutional. He supported it. When the facts must have come to him during the break, he wound back a bit. Well, I was about to say wind back, but that might have been. He turned around a little bit and said, we have to be careful. What are the facts? They got it wrong. And when I heard the member for Separia making a submission, I asked myself, is this senior counsel? I was embarrassed. Because the member for Separia, supported by another attorney at law, said it was trite, and told us that a judge, and then told us, called the judge's name. So and at that time, a puny judge. So I recognized immediately this was a first instance judgment. And one would have thought that senior counsel would have done some scintilla of research to recognize that there were possibilities of an appeal after that. It turns out on the facts that there was an appeal. I want back my silk. The Empress has no clothes.
48-4.
Sorry about that.
Member, again, let's retract and move on.
I was about to correct it and say the Empress has no silk, but I withdraw that. I withdraw that. I withdraw that. I was absolutely, as a member of parliament in this August chamber in the month of June, very embarrassed. And I'll tell you why, Mr. Deputy Speaker. I'll tell you why. In the other place, and I followed in preparation for this debate, I followed what transpired in the other place. And one Senator Gerald Ramdeen made the exact submission, and that was made on the 14th of March 2017. Let me quote him very briefly. And I want to put this I'm quoting, and I want to put this slowly, so the people of Trinidad and Tobago can understand where we are. That the Attorney General of Trinidad and Tobago is asking this Senate to amend a piece of legislation that has been struck down as unconstitutional by the High Court. And there was death stamping. This matter was advanced in the Senate, and that, as I told you, was on the 14th of March 2017. Subsequent to that, Mr. Deputy Speaker, a special select committee of the Senate was organized to give the Senate, including, of course, and led by the opposition in the Senate, the 6 of them, an opportunity to bring to bear their concerns about this bill. And that select committee met. And they reported to the Parliament through the lips of the said Senator Gerald Ramdeen on the 22nd of June 2017, after his submission of that in the Senate, when he spoke in the debate. And I want to quote from what he was saying in the Senate. Madam President, in speaking to the report that is now before the Senate, that is the report of the Special Select Committee, it is important that we acknowledge that this committee was set up pursuant to the recommendations that were made by the opposition for the purposes of bettering the piece of legislation that was currently before the Senate in the form presented by the Honorable Attorney General. And it was because of the forward-thinking way in which this legislation was presented that we are able to today to sit here to debate this report, which I think, Madam President, after the work of the committee, we can call on each bench, on each side of the Senate, say that we have a better piece of legislation if this report is adopted. He went on to say,
Mr. Speaker, stand in order, please. We were asked before not to use the material from the Senate.
And in order.
Mr. Speaker, the Speaker, the substantive Speaker prevented us from using...
Have your seat, please. Have your seat.
courtesy to my friend, I must say, when the substantive Speaker was in the chair, I sought her leave to quote from this. It's important for the public record. Don't cry. Deal with the facts.
Member, address the chair.
Thank you.
Address the chair.
Thank you. Madam, Mr. Deputy Speaker, and I just want to quote, as I indicated before, Madam President, we have been able to fix the unconstitutionality with respect to the detention of a person who is suffering from abnormality of mind. The length of that, and it goes on, it will no longer be determined by the President as it was before. It is now going to be determined by a court that accords with the rights that are given to each and every citizen of this country. And so it was commended as being fixed by their deliberations in the Special Select Committee. And that was in June, Mr. Deputy Speaker. The member for Siparia told us that they had a caucus yesterday evening, and they dealt with this matter in caucus. A meeting of parliamentarians to resolve their issues in preparation for a debate like today. And having done so, went home and on a frolic of her own, decided that section 67 and 68 of the Offences Against the Person Act were unconstitutional and came here today and advanced that. So she must have gone contrary to the caucus position, or at very least, contrary to the position taken by her lead. Well, I don't know who is the leader of the opposition, but by Senator Jerry Ramdeen. So she came here in advance and supported by my friend for Siparia. But what are the facts? St. Augustine. What are the facts? The matter was appealed. Appeal number P136 of 2010. Between Jason B. Sessa and the Attorney General of Trinidad and Tobago, and the panel of judges was Mr. Justice of Appeal Mendonça, Mr. Justice of Appeal Nolan Barrow, and Mr. Justice of Appeal Mr. Ralph Narayan.
When was it?
Mr. Narayan.
31st of January 2017.
On the 31st of January 2017. And the facts in this matter, and I have to deliberate on some of the elements so that the public who are listening to us, we televise these proceedings. So we must, for their sake. The appellant was charged with murder in December 1998, and on the 3rd of October 2001, he was found guilty by a jury. 1998? 2001, he was found guilty by a jury to be insane and unfit to take his trial. And trial judge York Sohon J., as she then was, ordered, and I quote, that you, Jason B. Sessa, be detained in safe custody in the St. Anne's Mental Hospital, that you be treated for your mental illnesses, that is paranoid delusions and mental subnormality, until the President's pleasure is known. The order of York Sohon was pronounced pursuant to Section 67 of the Criminal Procedure Act, Chapter 1202. The appellant spent 7 years and 9 months in the criminally insane unit at St. Anne's. On the 29th of July 2010, he pleaded guilty before Mr. Justice Holdup to a lesser offense of manslaughter, because remember the first before so on was just to assess his mental capacity. And he pleaded guilty to a lesser offense of manslaughter on the ground of diminished responsibility. The court took into account the period of time he spent at the hospital and on remand, approximately 12 years in jail. He was placed on a bond and released into the care of his sister Shanti B. Sessa. The appellant filed proceedings, these proceedings that is on appeal, on the 6th of February 2009, during the latter part of his detention at the hospital. And he had his arguments and so on. He argued, among other things, the infringements of his rights under sections 4A, B, and D, and sections 52A, B, D, E, and H of the Constitution. He also alleges that sections 67 and 68 of the Act are unconstitutional and not in conformity with the Constitution, inter alia, being inconsistent with the doctrine of the separation of powers. The attorney in this matter was the said Gerald Ramdeen. Yes. So he was intimately familiar with this matter. So even when he spoke in the Senate in March and said that it was unconstitutional, one would have thought that he knew better. But he went to a special select committee, he corrected it, offered the correction to the Senate, and then today in June, we have this member for Siparia coming here to take the same position, wrong as it is, and supported by my friend from St. Augustine. This is ultra ridiculous and embarrassing. I want back myself. And the reason why I'm spending time on this, because I am satisfied, as I told you, Mr. Deputy Speaker, that they have nothing else to argue against this measure. Correct. That was the only matter she advocated here today.
Member, she?
The member for Siparia.
Please, correct.
I'm sorry. And so, the Court of Appeal found itself having to deal with this. And in that challenge, the constitutional challenge, it is where Madam Justice Pemberton, as she then was, addressed this matter. the judge found, among other things, that Section 68 offended the doctrine of separation of powers because it gave the executive the power to determine the manner of the detention and how it is to be effected, which is part of the sentencing function entrusted to the judicial branch. That was the basis on which the court found it to be unconstitutional. The judge, and I'm quoting, she held that Section 68 required legislative modification to reflect that both the executive and the court had a role to play in administering the detention. It could not be saved, she said, and it had to be struck down in its entirety. That was the finding of the judge at first instance, on which the member for Siparia relied here today. Pegged her whole argument. And this is what, in part, the Court of Appeal had to say. Summary of the decision, and I'm quoting in paragraph 15. The appeal is allowed for the reasons given at paragraphs 31 to 41 below, and the cross appeal, because the state cross appealed that position, is also allowed for the reasons given in paragraphs 25 to 30 below. Right? And I told you Gerald Ramdeen was involved in this, Mr. Deputy Speaker. Very much involved. And I go now to page 11. And the court is speaking, paragraph 25, constitutionality of section 67 and 68 of the Act. And I quote, in my judgment, and this would be Mr. Barrow, Justice of Appeal Barrow, who is issuing on behalf of the three-court panel, the three Justices of Appeal panel. In my judgment, the decision of the trial judge on the constitutionality of sections 67 and 68 cannot stand.
Wow. No way. Wow.
The judge upholding the submissions of Mr. C. Prasad, I wonder if that's the same C. Prasad. There's a different one. Is this the same Mark C. Prasad?
48-8.
Member, again, with reference to the judge that you are presently quoting, I would like you to desist, right, and continue with your presentation.
At the front of the judgment, you have as well the panel of the judges who I named a while ago, and then you have appearances, and we have M.C. Prasad for the appellant. Is a lawyer, I'm not talking about a judge. And P. Elder S.C., senior counsel, and L. Lala for the respondent. So I'm going back to paragraph 25. Don't waste my time now. In my judgment, the decision of the trial judge on the constitutionality of section 67 and 68 cannot stand. The judge upholding the submissions of Mr. M. C. Prasad, same one who found documents in his office, found that both sections 67 and 68 were unconstitutional, being inconsistent with the doctrine of separation of powers. She found that section 67 offended the doctrine of separation of powers because it gave power to determine the length of the detention, a judicial function, to the executive. That is what the judge found. They are commenting on it. This hold...
48.2, my understanding, subject to correction, is that it is appealed to the Privy Council. And therefore...
Member, overruled.
I continue to quote Mr. Deputy Speaker. This holding is consistent with the decision of the Privy Council in the Director of Public Prosecutions versus Mollison, 2003.
Silence, please.
And the judge really quoted Lord Bingham in another judgment where at paragraph 5, Lord Bingham, because the matter that went to the Privy Council was a Jamaican case, and he's quoting Lord Bingham in the judgment at paragraph 27. The sentence of detention during Her Majesty's pleasure originated in the United Kingdom for reasons which are not in doubt. In the course of time, it came to be seen as inhumane to punish as if they were adults those who had, when committing their crimes, been children or young persons, not in the eyes of the law, fully mature adults. And he continues, it was a sentence of this character which was transplanted from the United Kingdom to Jamaica, and there's nothing to suggest that the amendments made to Section 29 as originally enacted on the effective substitution of the Governor General were intended to alter the character of the sentence. It is also a key feature of this sentence in Jamaica, although no longer in the UK, that the decision on release is entrusted to the Governor General as a member of the executive. So Lord Bingham was saying nothing is wrong if this authority is vested in the executive. The president. Where the Governor General replaced by the president in modern times. And he gave a number of authorities in support of this proposition. He also pointed out what was critical to the decision in Mollinson was the nature of the sentence pronounced on the accused. Because it was indeterminate, regard had to be paid not only to retribution and punishment, but also to the detainee's progress and development. Under the provisions of 29(1), those latter considerations fell to the executive rather than the judiciary, effectively allowing the executive to determine the extent of the punishment the detainee would undergo. So, Mr. Deputy Speaker, all the judge was saying here, Mr. Barrow, quoting Lord Bingham in support, is that nothing was wrong from the Constitution and its construction to allow this authority to determine how the patient and how long the prisoner should remain in treatment. Nothing was wrong if the executive would have done that. And so the decision of the judge was wrong. Paragraph 29. The facts of the Mollinson case were distinguishable in any event. That guy was already sentenced. In this case, it was different. The judge erred, and this is the comment of the Court of Appeal in relation to the judicial finding that the member for Siparia lauded here today and stood on. Hung her hat on, and her silk, her worn silk.
I'm not here now.
The facts of the case are distinguishable. The judge erred in not considering the natures of the appellant's detention. The key issue in this case, which the judge failed to consider, is what was the nature of the appellant's detention, having regard to the provisions of sections 64, 67, and 68. And he went on to quote these sections, and he goes on. It was for the executive to determine the measure of treatment the appellant was required to undergo. It is no part of the judicial function to care for and treat an accused person found by a jury to be insane or unfit to take his trial. Until he pleads to the charge and is found guilty, he does not come within the court's sentencing jurisdiction. And that is where it was distinguishable from the Mollinson judgment. And on that basis, the judge went on to say, Mr. Justice of Appeal Nolan Barrow, the trial judge thus clearly fell into error. And it is that erroneous position at first instance, which judges do, that the member for Siparia of senior counsel, how she got it, I make no comment. But of senior counsel came here today and hung her hat on, supported by my friend, as the
Silence.
only argument against this measure by our Attorney General on behalf of the government and the right-thinking people of Trinidad and Tobago to engender in these measures a small but significant movement towards tightening the platform, giving citizens or accused persons wider opportunity to choose whether you want a jury trial or you will take it with a judge. Not unknown. In complex fraud cases, even in England, they go for trial by judge alone. And I'm not talking about Ireland. Once the case is complex, like in fraud matters, they opt for trial by judge alone. And a judge is superior in the hierarchy of judicial things to a magistrate. And 90% of the cases we start here all go to the magistrate's court. And of course, there's a procedure for appeal. And of course, in the High Court, there is a procedure for appeal. I heard my friend from St. Augustine calling on me to support his erroneous position, which I rejected by my silence. But I know this. A judge, I have appealed many judgments and went to the Court of Appeal. Many. The judge may, and sometimes, I've tried honestly, you're looking for things to appeal on. That's your job. Sometimes you win, sometimes you lose, sometimes you win and you say, oh my God, you really get through here? And sometimes, on the other hand, you try your utmost, as happened to me when I did my first murder appeal, and felt everything was nice and easy, and I would have got past Mr. Justice of Appeal, President de Labastide at the time, and he pointed out to me that that's murder conviction would stand. He admired, he put it on the record, he admired my advocacy. He admired the way I made my submissions, my written submissions too. But he told me, tongue in cheek, that this quality of advocacy deserved a better case and the conviction should stand. And so it was. Just as the member for Separia lost a case here today in the eyes of the whole of the country. That's what she was. So I can spend a lot of time, I could spend more time on my legs here dealing with some of the petty and frivolous and trifling matters that my friends raised on the other side. And I will not waste precious parliamentary time. What I would do as I conclude, having debunked, having dealt hopefully adequately with the misdirection that the member of Separia put on us here today in this house, having gone off on a frolic of her own, and they're not here now to listen to the law and learn and be educated, I want back myself. Rather than spend more time on my legs here dealing with the frivolous and trifling issues raised by my friends in this House and in the Senate, all irrelevant and unnecessary as far as I'm concerned, I will rely in conclusion on the report of the Special Select Committee, which was engendered, encouraged by, called for by the opposition in the Senate, led by Senator Ramdeen, on a matter that he was grossly familiar with, intimately familiar with. He was the attorney in the matter to which I have just referred. And he told us in this report, as I conclude.
Member, again, your initial 30 minutes has expired, so you're concluding. Proceed.
I am most obliged. Most obliged. I do not propose to use all of it. I don't propose to use all of it. I simply want to say that the report of the Special Select Committee, which was laid and debated in the Senate, and I quoted from Senator Gerald Ramdeen on that occasion on the 26th of June, 22nd of June, as recent as that. He is saying there for the benefit of all of us, especially them, my friends on the other side, that they were satisfied that this constitutionality issue was properly advocated and dealt with in the Senate, in this committee, and he commended it to the House. So the measure or measures that the Attorney General has before us today would have taken those matters into account. Sound and solid measures. And I commend them to members of this House for their strong support as an effort on behalf of this government to put one more building block in place as we close the gap, as we make the fences taller so that the criminals can't use weak legal maneuvers and systems in order to beat us. All that is left after that, all that is left after that, whether trial by jury or trial by judge alone, is for other elements of the state to get totally efficient, get cracking, go out there and do the business on behalf of the people of Trinidad and Tobago. Arrest wrongdoers, prosecute wrongdoers, put them before the judge. Jury alone, judge alone, or with jury. Put them before the magistrates and send them to the place where the law says they should go for offending the rest of us in this country. Mr. Deputy Speaker, I thank you.
I recognize the member for Caroni East.
Mr. Deputy Speaker,
As I rise to contribute to this bill before the House, which is to amend the Supreme Court of Judicature Act and the Summary Courts Act, the Offences Against the Persons Act and the Criminal Procedure Act, and for related matters, I would have been extremely disappointed if I did not hear the usual verbiage from the member for Laventille West.
Member, I heard the comment. Please, let's avoid that. What you just made.
What did I say?
Listen, member for Barataria San Juan, I heard the comment.
I was reading something here.
Okay, kindly read it outside, please. Kindly read it outside. Right, because if that's the case, it's disturbing. Kindly read it outside the chamber. Member?
Are you telling me I have to leave?
Read it outside the chamber because it's disturbing, member for Barataria San Juan. I heard the comment. Proceed, member.
I would have been disappointed if we did not hear the usual derogatory type of language from the member for Laventille West, which people have become accustomed to hearing his type of speech in Parliament. And he doesn't understand the way that the people think about him now when he puts out that type of bile and vitriolic statements from time to time. And so when he speaks, he leaves. And his usual tone is to just attack and attack. But our leader of the opposition is someone who has faced the courts and worked for the poor person and has worked in the High Court, in the Appeal Court, and in countries across the Caribbean. She has done tremendous amount of legal cases and deserves fully her senior counsel. She is undoubtedly a legal luminary. There's no question about that.
They can't take it. They can't take it.
You're running now because the facts are there before you.
Can't take it.
Yeah.
Can't take that.
Can't take the truth.
Mr. Deputy Speaker,
Can't take the truth.
Again, once the member is on the floor, you listen in silence. Proceed, member for Caroni East.
the Attorney General started his discourse on this bill by stating, I want to quote him, the legislation here is to tackle the movement of criminal justice system in the right direction. Now, why are we discussing this matter about judge and jury, or jury alone, jury and judge alone? It is to deal with the criminal matters before us. I want to draw an analogy in terms of what is happening in this country at the moment. What we are trying to do here, Attorney General, is to treat the symptoms of the disease and not to treat the disease. We are looking at quick fixes to deal with the massive amount of cases coming before the magistracy and the judiciary. But are we, in fact, trying to reduce the amount of cases coming there by virtue of our work that we should be doing to reduce the amount of crime in Trinidad and Tobago? So the disease process is the amount of crime that is being perpetrated on a daily basis across the country. And if we are to get a hold on that and reduce the amount of criminality, we would see a reduction in the difficulties before the magistracy and the judiciary. And when we examine the statistics in terms of where we are in Trinidad and Tobago, and I quote the Caribbean crime statistics, according to the latest statistics, Honduras with 92 murders per 100,000, Jamaica with 40.9 murders per year per 100,000 people, are among the nations with the highest murder rates in the world. U.S. Virgin Islands has 39 murders per 100,000, St. Kitts and Nevis 38, Guatemala 38, Colombia 37 per 100,000, Trinidad and Tobago 35 per 100,000. So Trinidad and Tobago ranks number 7 out of the 10 countries which have the highest amount of murders around the Caribbean and Latin American countries. So this is the reason why the Attorney General could indicate today that the High Court has X amount of cases, 20,872. You have 9 judges in the dealing with the High Court, the criminal area, and 1 judge to 2,087 High Court cases. Now, you also indicated that there are 980 people are there for murders. If there are 980 people are there for murders, should he not be thinking, and the government should be thinking, what are we going to do to deal with the swift justice for these 980 people who are waiting the judicial process? What other avenues? Is it just legislation alone? It cannot be. And we had the Honorable Chief, the Honorable Chief Justice speaking about that situation where, by the process of having jury, the criminal process is being delayed. But then we have no empirical data to substantiate those statements. We would have liked to hear from, at the opening of the law term, on what basis that statement was made. And why have we gone on to decide that we want to get rid of the jurors in certain situations, or the jury? Would that really make a difference in speeding up the cases before the criminal justice system? For today, we haven't had any evidence-based or empirical evidence to substantiate the statement that if you remove the jurors or the jury, the process, the legal process will be swifter. There's nothing there to substantiate that. So we are basically moving with legislation, and the Attorney General spoke about the preliminary inquiry, which we supported, the plea bargaining, which we supported, the access to bail, which we supported, and of course, the traffic issue and the traffic matters to decriminalize the traffic offenders, which were about 100,000. So we are moving with legislation, but what are we doing with the process in the courts to help to speed up the criminal justice system? Over a number of years, Mr. Deputy Speaker, I have been associated with people in the legal profession. My wife has been an attorney since 1975, the first graduate of the Hugh Wooding Law School in 1975. And out of their class, they had 9 attorneys general for the Caribbean. And my deceased brother, Justice Gopeesingh, was an appeal court judge, and he acted as Chief Justice on 2 occasions. And I would remember when Justice Michael de Labastide took over from Chief Justice Bernard, there was a great amount of cases to be heard in the appeal court from the High Court in the criminal matters. And Justice de Laventille got together with his team and made a decision that within a 2-year period, there would be no matters lingering or pending from the High Court, which the Appeal Court would not have been able to deal with. And in so doing, he did it. His team did it. And that was a team of judges, justices of appeal, of repute, and great strength and fortitude, led by Michael de Laventille, Justice Ibrahim, Justice Sat Sharma, Justice Roger Hamel-Smith, Justice Gopeesingh, and later Justice Jean Permanent and Justice Zainul Hussain. And why is it then now can the judiciary not seek some methods of trying to reduce the amount of cases in a swift possible manner, and just not to rely on legislation to remove the jurors or the jury? I am positive there are many, many things that they could implement, which the member for Siparia spoke about earlier on. The CAT reporting. Judges do not have to write in longhand. The judges could have research people to give them some help. They could have more accommodation given to them. More judges should be employed. More magistrates should be employed. And the DPP's office strengthened. And we give a certain amount of strength to the judiciary, where you can have not only the high courts in San Fernando and Port of Spain, but across the country. If you have 11 judges doing criminal matters, and you have 2,087 matters on a yearly basis, and you have 980 murders to be looked at, you think 9 judges who are doing criminal matters could really deal with that? Isn't it something radically wrong? The facts are there before you. And you are a government in charge. You might say, well, we didn't do it as well as we should have done it, and that's why we are here and you are there. So what are you doing after 2 years? You cannot be looking for legislation to be the panacea for solving the criminal justice system. You have to think out of the box. And I personally feel, why has the judiciary have to be looking at construction of buildings across the country and going into infrastructure? Your work is to deal with the law and the judicial system. But you have the poor judiciary looking after the construction of magistrates' court and courts for hearing their matters and getting more place for them to work in. And I'll just give you one example. While I was Minister of Education, there was one area that they wanted to have a magistrates' court in Chaguanas. It was being built for a library. The judiciary asked for it to be given as a magistrate court. The cabinet took a decision to hand it over to them. And 2 years they had it. And absolutely nothing was done during that time. Not because of any incompetence, but because they possibly did not have the manpower and so on to deal with that issue in making that Chaguanas library a magistrates' court in reality. So we find ourselves doing some things there that could be avoided and give more room for the judges to do their work and to be expeditious and to be quicker in their approach to dealing with the amount of cases they have before them. Mr. Deputy Speaker, a number of speakers today spoke in terms of the pros and cons of the judge and jury versus the judge alone. And I want to just give some statements made by a very distinguished senior counsel in Trinidad and Tobago, one who has held a respect in the criminal justice, in the criminal arena as an attorney practicing criminal law. And that is Mr. Israel Khan, who on a guest lecture at the Hugh Wooden Law School on Tuesday, 14th March 2017, just about 3 months ago, trial by jury and other relevant issues in the administration of criminal justice. And he started his discourse, and I quote, "Trial by jury for the people of the Republic of Trinidad and Tobago and the other Commonwealth Caribbean territories means more than a mere institution of justice in that it facilitates the opportunity for the ordinary God-fearing citizens of good character to participate in the administration of the criminal justice system in the delivery of justice." And he goes on to say, "Indeed, the jury as an institution is the cornerstone of the criminal justice system in the respective Commonwealth Caribbean jurisdictions, and thus under the doctrine of the separation of powers, it is indispensable to our participatory democracies because it embraces and supports the concept of government of the people, by the people, for the people." And this, he continues to say, "For the accused, a fair trial demands that both the prosecution's and defense's attorney must be evenly matched in competence and experience. In the final analysis, the jury will decide whether the accused is guilty or not guilty." And he goes on to say, "Trial by jury is now being used as a scapegoat for the inefficiency of the judiciary and the criminal justice system in the delivery of justice in Trinidad and Tobago." That's a quote from Israel Khan. And he mentioned that the Honorable Chief Justice had called for the abolition of jury trials, stating that it was a cause for delay in the criminal justice system. And he went on to give an example, pointing out about the Bhoendradatt Coolman case. And there was a report on that matter by a reporter, Mr. Ramdas, who had quoted at that time. He quoted from the Chief Justice's speech, and I quote, "If the current inefficient and ineffective system is what the country wants to have, then fine. But don't blame me for the consequences. I was appalled at the conclusion of a recent matter that occupied the court for over 2 years to hear bleating about the vindication of the jury system. Of course, for those who were acquitted, one can well understand their sense of elation." So that was the Honorable Chief Justice making a statement on the opening of the law term 2016-2017.
Honorable Member,
Yeah.
again, all members were given certain leeway with
Sure.
regards to the standing order that speaks about reference to the judges and the Supreme Court and so on. Again, please move on accordingly. You would have given you the leeway to make the point, but let's don't harbor there much, please.
Thank you, Mr. Deputy Speaker. I respect that at all times, and I will not go into the conduct of the judicial system. But let me quote what another senior counsel, Mrs. Pamela Elder, said, President of the Criminal Bar Association. She told the media, these are two senior counsels with tremendous reputation in the arena of the practice of criminal law. And she told the media she would prefer to burn her robe than have to practice in a juryless system. Why would a senior attorney with those years of experience be saying such a thing? Why would another senior counsel with close to over 40 years experience in the practice of criminal law be saying these things about removal of a jury system? And Senior Counsel Israel Khan continued to say not only what Pamela Elder, Senior Counsel, said, and I quote, "Only a dictator or a fool would support the abolition of trials by jury in this country." That's how deep they feel about the removal of the jurors and the jury system from the criminal justice system. Two senior attorneys, and the Honorable Attorney General indicated at some time in the past that there are probably less than 15 lawyers of eminence, well, not, he didn't say of eminence, but we recognize that 15 top lawyers practicing in the criminal bar. There are only about 15. And if two of the senior ones can say that, I want to ask the Attorney General when he is responding, what has he got to say about that? And these two attorneys have led the Criminal Bar Association on many occasions and well respected, not only nationally, but Caribbean-wise, in their proficiency and their skills and their knowledge. And Mr. Khan said, this is a multiracial and multi-religious society, and we cannot have a single judge determining whether an accused person should be convicted and sentenced to death or a long term of imprisonment. He goes on to say, trial by jury is the only opportunity that the ordinary God-fearing citizen get to participate in delivering justice. Why are we seeking to remove it? Your excuse is that you want speedier justice system, but you can't show scientifically and empirically how that is going to help to speed up the justice system. And my colleague, the member for St. Augustine, made the points. I don't have a clue about it in the courts, but to get a jury is less than an hour. And how many juries have been put aside and left for a while and preventing the delay and causing the delay in the courts? That hasn't caused the delay. It's the other issues that the Attorney General and his department got to look at. And one of the most famous and celebrated jurists, Lord Devlin, stated some 61 years ago that, and I quote, "The first object of any tyrant in Whitehall," speaking about the British Parliament, "would be to make Parliament utterly subservient to his will, and the next to overthrow or diminish trial by jury. For no tyrant could afford to leave his subjects' freedom in the hands of 12 of his countrymen." This is what Lord Devlin said. And he equated the removal of the jury service, the jury, as a tyrant wanting to have his own way. Is this what we might possibly see? The question has to be asked. And when the member for Laventille West speaks in a summary about we want to have the magistrates to lock up everybody and put them before this and put them before that, are we seeing before our eyes the tyrannical approach that we are seeing right in Parliament before our eyes?
That is important.
So that is what Lord Devlin stated 61 years ago. So we submit, Mr. Deputy Speaker, that a legitimate expectation that a constitutional right exists to be tried by judge and jury for those serious criminal offenses which were triable in the Commonwealth Caribbean jurisdictions before the commencement of the various constitutions, and no law may abrogate, abridge, or infringe that right unless Parliament, by a special majority, enact legislation which demonstrates it is reasonably justifiable in a society that has a proper respect for the fundamental rights and freedoms of the individual. We don't want tyrannical approach towards giving decisions by any particular judge. We live in a multi-religious, a multicultural society, and therefore people have their biases. And isn't it better to go through a matter to be heard before 12 people or 9 people than to be judged by one person? What happens to that person if that person, as has been illustrated by the member for St. Augustine on a number of occasions when he practiced before the courts? And many of the attorneys will give similar examples. We all know that from time immemorial, the fundamental human right to be tried by judge and jury on a charge of murder existed many, many years ago, centuries ago. And that has been common law. Common law, when we got independence in 1962, we accepted the common law principles from the British system. And when we got independence in 1976, not independence, constitution, republicanism, we had to draft a constitution. And so Ellis Clark was one of the persons who helped to draft this constitution, a very distinguished president. And then there was another justice of appeal. The people practicing in the legal profession will tell you that he was another person who was very anchor with the whole constitution, and he could have quoted the constitution from beginning to end. His name slips me at the moment. But what are we trying to do? Something that has been common law, you're trying to remove it on flimsy excuses without any scientific basis for making that decision. And then, as has been indicated by our colleagues, they're nibbling away at
silence.
They're nibbling away at our democracy, bit by bit, until all our democratic institutions will be eroded in Trinidad and Tobago. Slowly, but deliberately, bit by bit. So where are we going to become? A banana republic? Are we going to go down the road of Zimbabwe? Or are we going to go down the road of Venezuela? We have to be careful about how we do things. And not because the Honorable Chief Justice, who I have a lot of respect for, and everybody must have respect for the people in high offices, but when he makes a statement that having a jury service is shocking.
Member,
Yeah,
again,
I hear you. All right, I wouldn't go there.
I give you the leeway already. Let's don't go down that road.
Okay.
Again.
Okay, the point is made.
You are the new minister.
You can't use that as an excuse to say that you have to bring the abolition of the jury service, the juries. And there's a very great legal luminary, somebody by the name of Margaret de Murillo, in her book, Fundamental Rights in Commonwealth Caribbean Constitutions, at page 36 stated, and this is part of the paper that Israel Khan gave in his speech to the Hugh Wooding Law School students, and I quote, "The absence of a right to jury trial may well rob the West Indian states of a constitutional-based protection from possible attempts of government to bring unfounded changes in order to eliminate political enemies from judicial personage too responsive to the voice of higher authority and from corrupt or overzealous prosecution.
You have an additional 15. You care to avail yourself? Member for Caroni East. You care to avail yourself of the additional 15? Proceed.
To the meat of my matter. Mr. Deputy Speaker, I like when you're in the chair there. Never have a senior moment. The brain is as sharp as ever.
What you're doing, you're challenging his qualification.
This person, Margaret Demario, in her book Fundamental Rights in Commonwealth Caribbean Constitutions, we need to repeat this. The absence of a right to jury trial may well rob the West Indian states of a constitutional-based protection from possible attempts of government to bring unfounded changes in order to eliminate political enemies from judicial personage too responsive to the voice of higher authority and from corrupt or overzealous prosecution. Mr. Deputy Speaker, this speaks volumes. Margaret Demario, a legal luminary, would have been seeing the sands, when you're playing in the sands, what happens. So this legal luminary says, eliminate political enemies from judicial personage too responsive to the voice of higher authority and from corrupt or overzealous prosecution. Why do we want the elimination of the jury aspect in our criminal justice system? I'm just asking, is this going to be an end to a means to an end? Is there a subliminal thinking behind all of this? I'm just asking the question. And let me just quote this. The jury system is described as the lamp that shows that freedom lives and a wheel of our Constitution. Yet, our leaders in the judiciary and our Attorney General seriously doubt this. And the Attorney General is now proclaiming their desire to abolish trial by jury. Not altogether, but we said that you're nibbling away at it. Is there a need for a radical change? And the same legal luminary, Margaret Demario, stated, law and legal systems are already so alienated from the common man and engender so much distrust in the governed and governors that juries are powerful demonstrations of justice in progress. Why do you want to eliminate it? Juries are powerful demonstrations of justice in progress. In our classist and elitist legal system...
Member, would you give way, please?
Just a few minutes again. Let me make it. It is perhaps the last bastion of grassroots democracy. In our classist and elitist legal system, it is perhaps the last bastion of grassroots democracy. Why are we removing the last bastion of grassroots democracy?
I will remind him. You wait. Continue.
So, Mr. Deputy Speaker,
5 minutes. You let us see.
the Honorable Chief Justice, the Honorable Attorney General went on to say, whether a trial by jury is an encumbrance. He asked the question.
Members,
I've quoted enough examples
silence.
to show that the jury system is not an encumbrance. And of course, he went on to indicate that in the Bahamas, there's an express statement in the Constitution And the express statement has the right for jury trial. And there are certain other jurisdictions do not have it within their constitution, but they have inherited by common law. So why are you removing it from common law? Yeah. I wouldn't answer. The Attorney General began to make the statement of arguments for and against. Minister Dayal Singh, a member for St. Joseph. Yes, certainly.
Thank you, member. Member, could you kindly tell me what section, what clause speaks about the abolition of trial by jury? Please.
All the clauses that indicate that you have a choice to make. The accused can discuss with his attorney and they have a choice to make. But I'm saying that should not even be a consideration in this scenario now. There should not be that choice given at all. What is it that we are trying? And the member for St. Joseph said, now is the right time to do the right thing. Now is the right time to do the right thing. I have my executive MBA, and I have an MSc in international relations with distinction. And I did 2 years of law. 2 years, yes.
It is not evident.
Yeah. Very evident. Yes, sir, Mr. Speaker. I don't need to practice that. I'm surrounded by lawyers all the time.
And good ones.
And good ones. Very good ones. My best friend is one of the best attorneys in Trinidad. And I wouldn't call his name here.
Please.
Yes, Mr. Speaker.
Address the chair to avoid those kind of circumstances. Yeah.
I will listen to you at all time and I will face you. Mr. Deputy Speaker, I want to repeat before my time ends that all that the member for Laventille West has been speaking about for a lot of this afternoon is the fact that the case that was related to Section 67 and 68, where
Of what?
Section 67 and 68 of the original bill, where the ruling of the High Court judge was struck down by the ruling of the appeal court. But that matter now is pending before the Privy Council.
Silence.
It is being appealed to the Privy Council, and that I understand that matter is going to be heard pretty shortly, whether the leave will be given to go to the Privy Council. So as it is at the moment, we are in the middle of making laws with laws that are making amendments to laws which laws are questionable at this moment because the matter is going to be heard before the Privy Council. So we want to make that abundantly clear. The matter has not been finally determined. So the original statement made by the leader of the opposition still holds because it is bad law at the moment. Yeah. The matter is still being questioned. The Jamaica Gleaner, Mr. Deputy Speaker, had an article, Jury Trials, Things of the Past. And it said, the judge is supreme on the law. However, the coming together of 12 persons on life issues is richer and hence wiser than any single judge. This is Jamaican Gleaner, an article, a commentary, Jury Trials, Things of the Past, January 30th, 2016. There is a connection between the vote of each member of the electorate to decide on who will govern and the verdict of a jury. They are both participants in the democratic process. They give flesh to the concept of the separation of powers. They secure the independence of the judiciary from the other all-powerful arms of government. In short, they guarantee a vital check and balance between tyranny and good order. The random selection of jurors is void of the influence and or control of the state. As regards the selection of judges, there is a Judicial Service Commission, but how our judges are appointed is not entirely void of the influence of the state. That is the Jamaica Gleaner saying that. The commission is appointed by the state. The net result is that regarding a defendant who is charged for a serious offense, trial by jury is our only guarantee of a verdict, far removed from any political influence whatsoever. The author laments the demise of the jury system. I want the Attorney General and his team to hear that. The Jamaica Gleaner, Jamaica, where it's one of the highest crime rate in certain areas. And this is what is being on an editorial in the Gleaner. It concludes, Jamaica, the boulders of the great protective wall guaranteed by our jury system are coming down. That's a serious. The boulders of the great protective wall guaranteed by our jury system are coming down. This ought not to be taking place here. If you, how much time again now, Mr. Deputy Speaker?
4 minutes.
Right. If we want, thank you, Mr. Deputy Speaker. If we want to speed up and increase the pace of the judicial process in our criminal justice system, we have to find alternative means which are there for us to use our brain power, think out of the box, and to do the things necessary to help in expediting the judicial system, not by removal of a jury system where you know it is not going to make a difference in terms of the speed of the administration of justice. It is not going to make any difference whatsoever. So, when we look at the figures of crime by offense, and over the number of years from 1994 to 2017, it is quite clear we have to do something about the increased criminality. That is where we have to tackle the issue. If I'm a practicing medical person and I go to treat symptoms and don't treat the disease, I would be failing the patient. You have to treat what is causing the symptom. And therefore you have to find out what is going on in the country that is causing the increased criminality and therefore reduce that. And if you can't do that, don't come to other areas to do a quick fix and a small patch up here and there. You will not succeed. You will not succeed at all. And why jury trials are important in a democratic society. I have a paper here that was the National Judicial College, a paper prepared by the National Judicial College and www.judges.org. The National Judicial College is grateful for the support of the International Academy of Trial Lawyers. And I end my contribution by saying why jury trials are important to a democratic society. The American jury trial is a constitutional right. The Founding Fathers believed that the right to be tried by a jury of your peers was so important that it merited inclusion in the highest law of the land. Amendments 6 and 7 of the Bill of Rights contain this right. The jury trial is a vital part of America's systems of checks and balances. The Founding Fathers included jury trials in the Constitution because jury trials prevent tyranny. Trial by jury is a unique part of America's democracy. Jury trials provide an opportunity for citizens to participate in the process of governing. Jury trials educate jurors about the justice system. Jury trials provide a method of peaceful dispute resolution. Jury trials offer the voice of the people to the civil and criminal justice systems. Mr. Speaker, Mr. Deputy Speaker, I don't need to make any further points on this matter, but to close by saying, going down this pathway, Madam Speaker, is going down the wrong pathway. And we're seeing evidence of possibly a tyrannical approach to things in this country, the erosion of our institutions, the erosion of our democracy, the subversion of human rights, and therefore it is unacceptable for us at this moment, based on what we have said before and what is happening in this country, for us to even think that we're going to fully accept what you have been proposing. Find alternative routes and measures to deal with it, and we'll go along with that. Thank you.
Member for Chaguanas West.
Thank you, Madam Speaker. Madam Speaker, I think that this matter has struck certain emotional chords because it deals with this bill, which is entitled An Act to Amend the Supreme Court of Adjudicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters. Madam Speaker, the Attorney General in piloting the bill indicated that, look, that there are arguments for and against the trial by jury, and that one option that the government as a policy position has taken is trial by judge alone without a jury. In our tradition, Madam Speaker, we have a composite tribunal. People have to be tried in the criminal legal system beyond reasonable doubt, and you have a composite tribunal comprising of both the judge and the jury. The judge sums up the evidence and gives direction in law, and the jury decides on fact. That is all well established. And so this is another option, a choice that is being put before us. But when you listen to the utterances of the Honourable Member for St. Joseph, you would think that the intention of the government is to get rid of trial by jury. The whole tenor and focus was in that direction. The Honourable Member speaks of, he begins by telling an untruth, Madam Speaker. He first says that the Magna Carta does not speak about trial by jury. I would ask the member to make reference to Article 39 of the Magna Carta, and you would see that you would judge by your peers in the context of the time. That was the trial by jury. So you begin your process with an untruth, and then you go on to say about, the Honourable Member goes on to speak about the romanticizing of the jury. Now, when you have men of the gravitas and caliber of John Adams of first Abraham Lincoln, and I quote, Madam Speaker, why should there not be a patient confidence in the ultimate justice of the people? Is there any better or equal hope in the world? Then you have John Adams. John Adams referred to the jury as the heart and lungs of liberty. Thomas Jefferson considered trial by jury as the, and I quote, the only anchor ever imagined by man by which government can be held to the principles of its constitution, end of quote. Alexander Hamilton says, with respect to jury, the latter represents it as a very palladium of free government. These are men who founded and wrote the American Constitution. These are men of gravitas. These are not no romantic Romeo and Juliet, as the member of St. Joseph would like us to think. Madam Speaker, it is in that context, Madam Speaker, then we can look and we get closer home, and we'll go back to the fons et origo of our jurisprudential system, the British system, Madam Speaker. And you have Lord Devlin, who observed that each, and I quote, Madam Speaker, each jury is a little parliament. He added that the first object of any tyrant would be to make parliament utterly subservient to his will. The next would be to overthrow or diminish trial by jury. he concluded with characteristic eloquence that trial by jury is more than an instrument of justice and more than one wheel of the Constitution. It is the lamp that shows freedom lives. So, Madam Speaker, this is no question of any kind of romanticism. This is a question of how now do you deal with this attempt through legislation to bring trial by judge alone. Madam Speaker, in seeking to bring about anything that is new, there are challenges. And that therefore the environmental challenge and the context of your society in which which seek to introduce this device called trial by judge alone in the context of the High Court. I know the Attorney General and other members spoke of the role of the magistracy. But trial by judge alone has raised certain suspicions in the level of members, senior members of the criminal bar, enunciated by my colleague, the Honorable Member for Caroni East, and I will not repeat. But I want to indicate, Madam Speaker, that there is an empirical basis to show that trial by jury is not what the members opposite make it out to be. They make it as if it is that the democratic system cannot fathom, cannot engage, and cannot continue to engage trial by jury because it is a delay and it is costly exercise. And that is my point. Where is the empirical basis? The Honorable Attorney General loves to regale us with data. Unfortunately, in this instance, the data is absent as to the role and function of the jury in this country. Madam Speaker, in a study, in an article entitled "Trial by Jury, Has the Lamp Lost Its Glow?" by Tricia Harris, a law professor from the University College of London, Journal of Undergraduate Research, Volume 3, Issue 2, December 2010. This is a study, Madam Speaker, carried out with several thousands of cases over the period of the Ministry of the Crown, 2006 to 2008. And this is, and I will quote from this article, Madam Speaker, subject to your permission. The view reached by Professor Cheryl Thomas in her large-scale analysis of jury verdicts suggests that juries are overall efficient and effective. Her findings reveal that once sworn, juries are rarely discharged, less than 1%, and once they begin to deliberate, they reach a verdict on virtually all charges, hung juries occurring on only 0.6% of charges. A study concluded that contrary to popular belief, there were no significant differences in jury verdicts for white, black, or Asian defendants. All white juries did not discriminate in acquitting white defendants charged with racial offenses more often than racially mixed juries. There were no courts with a higher acquittal than conviction rate, dispelling the myth that there are courts where juries rarely convict and juries are not primarily responsible for low conviction rate on rape allegations. So, Madam Speaker, so what has emerged, therefore, is why are we at this stage? If there is no empirical basis, this piece of legislation has been an initiative of the incumbent Chief Justice. It did not find fertile ground in the administration of the People's Partnership. In fact, Madam Speaker, when the former Attorney General came with this piece, draft legislation, before the cabinet, he was given short shrift on it, and that therefore it could not find fertile ground within the People's Partnership administration. Fortunately or unfortunately, it has now found fertile ground in this current administration, Madam Speaker. You see, Madam Speaker, what this is doing, and I think it made reference was made briefly by my colleague, the member for Caroni East. you begin to go this route, then you will not democratize the rule of law in your country. Look, in this country, the ordinary man who is randomly chosen from the electoral list, the only opportunity they get to influence and participate in the judicial process is as a juror. They participate and they decide the fate of members charged of the citizenry, larger citizenry, charged with various offenses. And that is the way they participate. That is the way it brings legitimacy. Legitimacy to the rule of law. And one cannot underestimate that, the role of legitimacy in a society, in any society, but more so in a society so diverse as ours. And Madam Speaker, what is the raison d'etre, the reason why people have public confidence in the criminal justice system? People have confidence in the criminal justice system because they are participating in the criminal justice system. And if you seek to isolate that, or if you seek to begin the process of eliminating that, then you are going to corrode the very architecture of this society, Madam Speaker. Madam Speaker, you see, trial, criminal, what is this? Why this matter is so touchy? It is because, unsensitive, it is because you're dealing with criminal trial, which give rise to imprisonment, whether it is death, in terms of sentencing. So therefore, what we want in our system is an independent and impartial court. We want fairness. We want fairness in the context that justice must not only be done, but seen to be done. And that therefore, when you have a situation where you have 12 members or 9 as the case might be, you have a situation where in this small society, it is hard to get an opinion, but you'll have the pulling and tugging, and you'll have the dynamic of the relationship within the closed doors of the deliberations of the jury. And I heard, I think, the member for St. Joseph speak about that the deliberation, they do not provide reasons, that the jurors do not provide reasons. But the way the system has evolved, they are the arbiters of fact. They are not the arbiters of the law. The judge sums up the evidence and the law, and the jury do the findings of fact. And on the basis of that, together with the law, as I indicated before, and the evidence summed up by the judge, you have this composite tribunal determining and providing legitimacy and confidence in the system. Madam Speaker, when you look at countries in which you do not have jury trial, I notice members stay away from that system. In India, you do not have trial by juries. And you have a serious compromising of the legal system. Madam Speaker, in an article entitled "Why the Jury System is Superior than the Judge System in India," and I will quote Madam Speaker. And in this article, they indicate that, look, when you do not have the juries, then the judges themselves become prone to be reached to. There is a kind, what is they call nexus proneness of the judiciary through the criminal element. Nexus proneness of the judiciary, and they go on to indicate that if you're a criminal in an area and the judge is sitting in that area, there's a nexus proneness that emerges. And then the second element that influences and therefore brings about a bias is the nexus proneness of the criminal lawyers with the judge. I think my friend, the member for St. Augustine, made reference to that in a different context. But what you have is that, and then they go on to talk about, Madam Speaker, in the article, about the reference of judges, because they are doing this all the time, become case hardened, and that therefore they remove themselves from the day-to-day experience and what the jury brings, and they are now arguing for the return of the jury in India. They are arguing that the day-to-day live experience that the ordinary citizen brings about a different perspective and therefore lends itself to the development of the law. Madam Speaker, so that the problem, therefore now you have a jury system alone existing in India, no jury existing in India, only judges alone, and you have that problem that is indicating that you have, how can I put it, Madam Speaker? You have a much more specific system that will allow much more people to be affected. But in a jury system, it is so diffused that the chances of that nexus proneness it's too hard to arrive at, Madam Speaker. Madam Speaker, many years ago, I read a book called Judges on Trial by Shimon Sheetreat, edited by Gordon J. Borey. And there has been a more recent edition, Madam Speaker, and in 2013, the more recent edition of this book, Judges on Trial, Cambridge University Press, and is subtitled The Independence and Accountability of the English Judiciary. Authors Shimon Sheetreat of the Hebrew University of Jerusalem and Sophia Turen of the University of Cambridge. And Madam Speaker, in this book, they talk about the whole area of the independence, how do you support the independence, the impartiality, and the legitimacy of, and therefore stroke public confidence in the judicial system. And Madam Speaker, so whilst that is the situation, and we will return to that text in a bit, I want to make reference, Madam Speaker, to the Mount Scopus International Standards of Judicial Independence, approved in March 2008 and consolidated in 2013. And I want to make reference to what is stated at page, at 1.4. 1.4. And it says, building and maintaining culture of judicial independence. And I quote, Madam Speaker, 1.4, every society and all international bodies, tribunals, and courts shall endeavor to build and maintain a culture of judicial independence that is essential for democracy, liberty, rule of law, and human rights in domestic system of government, and is a necessary foundation for world peace, orderly world trade, globalized market, and beneficial international investments. And they go on, Madam Speaker, on 1.4.6. The ethical traditions and code of judicial conduct cover the judge's official and non-official spheres of activities and shield the judge's substantive independence from dependencies, associations, and even less intensive involvement which might cast doubt on judicial neutrality. So ethical considerations are important. And public confidence is important. So, Madam Speaker, when you see today's newspaper, which was made reference, and I will not read the headline, but I want to read a part of it, which says in today's Guardian, at page A3, respect us, so the quest is for respect. With his voice cracking, Myers said, how I could put my trust in all you. This is stupidness, ma'am. I have kids at home. This is hurting me. Myers said he's now feeling like a puppet on a string, since his matter have to restart, although one witness was left. So what you have? You have in this very society, not by judge, not by jury, by judge alone, a situation which has emerged, which has thrown the questions over the legitimacy of our court system, of our judicial system, and that therefore what we have to do is to recognize the environment in which we are seeking to bring this piece of legislation. And this is the point made by earlier on by the member for Siparia. Inopportune timing. The environmental factors therefore now cast doubt on the legitimacy and the efficacy of the rule of law, having regard to what is happening right now within the judicial system. Madam Speaker, so that therefore, if our quest is through this piece of legislation, is to bring in another option for the accused by having a trial by judge alone in the current circumstances, then it is questionable whether it is an appropriate mechanism. Because if you do not have the confidence and trust, as Mr. Myers indicates, the lack of respect by the system, then you're going to have a serious problem as to the legitimacy of the rule of law in this country. Madam Speaker, having regard to the nature of our society and having regard to the culture of our society, we must tailor legislation that is appropriate. In his work, more recent work, Madam Speaker, the Underachieving Society, Development Strategy and Policy in Trinidad and Tobago, 1958 to 2008, by Terence Farrell, at page 250, and I quote, Madam Speaker, "The third cultural characteristic of Trinidad and Tobago, and perhaps Caribbean society as a whole, is the precedence of relationship over rules. The significance of personal relationships, which may have an ethnic dimension, was identified by the Off Commission of Inquiry, speaking on the apparent attempt to influence the placing of a contract in these terms. And I quote, "Rather than indicating corruption, we think this is more a reflection on local culture in a society where no one is anonymous and business at any level is made more complicated by the undoubted existence on many levels of personal relationships involving predispositions to favor one person over another. Such a culture cannot be changed, but the consequence in terms of potential corruption must be guarded against." So you understand the cultural environment, Madam Speaker. What Terence Farrell is saying is that relationships trump the rules. And if in a situation like that, when you seek to bring a judge alone in the criminal arena, then relationships will trump the rules. This is a systemic issue. It is not an attack on the judiciary. It's a systemic cultural issue we have here, Madam Speaker. And when you look at the more recent newspaper headline, in which there's an apology and says that we are the most powerful ethnic group. We are the most powerful ethnic group. Although we have only 1%, we constitute only 1% of the population. And you tie that to the culture of where relationship trump the rules, meaning, the law and the legislation, then you have a serious problem in your society, Madam Speaker. So my thinking in this matter, you require to nurture the ground. You need to be much more database than you have been, Honorable Attorney General. And I think that this piece of legislation ought to be delayed, and that therefore because it will not impact upon the manner in which and impact positively in getting the courts to deal with matters before it. It will not impact upon the backlog. What in fact it will do, Madam Speaker, is to bring question mark about the legitimacy and public confidence in the rule of law and the arm that provides that, the judiciary. Madam Speaker, I thank you.
Thank you. Thank you very much, Madam Speaker. Madam Speaker, I rise to make a brief presentation and to raise just a couple issues emanating from the contributions of colleagues. It is not my intention at all to be very long or for that matter to engage in any vitriolic presentation or any personal matters, but just to raise really two questions arising to clarify one matter raised by Laventille West and a couple issues raised by the member for St. Joseph and Minister of Health at this time. Well, I address all my colleagues opposite in the capacity they rose and in the ministries they have, because, Madam Speaker, we are being told from a television announcement that a cabinet reshuffle is imminent, so I address them as they are now and not what they may be within the next hour or so. Madam Speaker, the member for St. Joseph, colleague from St. Let's forget the ministerial office and just say colleague from St. Joseph, gave the impression that his presentation hinged on the constitutionality issue. And the leader of the opposition was very clear that at this time, today, we were not raising the matters of the constitutionality. And therefore, my colleague from St. Joseph had to constrain himself to 20 minutes or so because he couldn't carry his full text prepared. But, you know, Madam Speaker, this matter of jury versus judge is not a new debate, it's a very old debate. In preparation for today, in the event that I was called upon to speak, I had cause to go back into my notes and my computers and so on to look at the database I have. And I recall at doing law, you would get exams, you would get papers and essay to write and so on. And I want to assure my colleague from Degomartin Northeast, I did complete that LLB degree. And I would indicate that I did it in a record 2 years, while others may have taken 8. At the Heward Law School, incidentally, where the matters of jury came up, I was looking through my file because it's a big issue there, and we debated that at length and so on. But it's also an old issue; it's not new, and there is a temptation to get into the discussion and quote Professor X and Dr. Y and legal scholar A and legal luminary B and so on. But it's an emotional issue, and it is almost the same emotion in the jury discussion than in the marriage bill, that we had in the marriage bill. And you ask why? And there is a similarity between the two, is that they are both matters that people have deep personal views on, almost cultural views on. And it is the same passion you heard on the marriage bill you will hear in the jury discussion on jury. Because there's a passion, because this system has existed so long, and there are some people who believe that a jury is a buffer between an accused. Madam Speaker, yes, I know my colleagues upstairs opposite will be jittery at this moment, but I challenge you all to relax and listen. I mean, nothing worse could happen to you. So, Madam Speaker, they're all glued on to their phones, but yeah, I was saying that this jury business is a passionate business because it is seen as a buffer between authority and an accused, a defendant. Throughout the history of mankind, we actually go full circle. Today, we are asked in this bill to approve a position of judge alone. But there was a time in history when it was judge alone. It was the king. It was the Maharaja. It was the personal court of, the religious or spiritual leader. It was in some cases an elder. So it has happened before in human history. And the jury was meant to come in and step in between authority and an accused person, that his or her peers become that power that determine guilt or innocence and effectively your life. And this is why this matter of jury is so passionate. Now, I did not hear the Attorney General in moving the bill speak about consultations. I imagine they would have had many. I don't know. I personally did not see anything in the newspaper. I did not see any media release. I did not see any coverage of any consultation on this matter. And I would have thought, and I could be wrong, Madam Speaker, because I do not watch a lot of news and follow everything. But I would have thought on this matter that is so passionate, where people hold such deep views and deep-seated views, that there was a need at this time in 2017 to go to the people through the City Hall, local government, civic organizations, human rights organizations, and they get a view of the population that you want to make such fundamental change. Who knows, the people may have come out and said, look, do away with jury altogether. You don't know. They may have come out and said, no, don't touch that. Don't touch that. So I would like to ask whether consultations were held, whether it was held, and if so, with who? It must be public. I see phones moving around. If you all have any information to share, do tell us. Because I myself am concerned with the career of my colleagues. But I will address the now sitting Attorney General. And I would ask him whether consultations were held. I understand Laventille West gone already, so he's not even in the House. But good reason. And if consultations were held, with who? When? Because I want to say, even at this stage, notwithstanding this piecemeal approach, that it may not be too late to have wide-scale consultation on this critical, passionate matter involving the judiciary, rights, persons' perception of their rights, and so on. So I ask you to consider that. Yeah? Now, the member for Caroni West carried an argument which I don't want to repeat, but I want to endorse. Chaguanas West carried an argument I want to endorse, which is really, do we have data? Do we have data to suggest that one of the problems with this backlog of 100,000 cases, one of the problems with the slowness of the system, one of the problems with money, we spend maybe too much money, that is related to the jury system? I suggest we don't have, or I have not seen that bit of information. And the Attorney General is one to tell us a lot about statistics and that type of thing, because I think he also has a numeric mind and like to use statistics. But we would like to know what statistics we have to suggest to us that the jury system is responsible for slowness in the process, responsible for spending a lot of money. What do we have on that? It cannot be that the jury system and the jury system we utilize now is preventing the detection of crime. Because we argue that whether you have a judge alone or you have a jury alone, you first have to charge, arrest, detect, and then go before the court. So that the jury system, you cannot be making this change today with the anticipation that you will increase the detection rate. Because this has nothing to do with detection rate. It may have to do, if you bring the evidence, with conviction and so on. So, Madam Speaker, I put that too on the board. Madam Speaker, in the information we have, Madam Speaker, in several Caribbean territories, this matter arose. And from the evidence we have, from the discussions that have taken place and so on, it is a matter that throughout the Caribbean, we have been receiving information that it is occupying the minds of persons nearby who share similar jurisprudence as we do. In Barbados, I'm told that the Queen's Counsel, DPP there, Mr. Charles Lee Cock, expressed the view that it was time that Barbados move from jury to judge-alone trials. When he did this, there was some public uproar, and one newspaper editorial there raised this matter that the government ought not to proceed in this manner without consultation with the public. and this was Barbados, Madam Speaker, where the matter was raised. The matter was raised. In Jamaica, I understand the matter was also raised there. The matter was raised there. And again, consultation was the way to go. In outside, but it's still within the Commonwealth. In Australia, or parts of Australia, we have had comments about this as well. And the general view was that we should not throw out the jury because we believe that the system is slow or expensive, as the case may be. Now, happily today, in a sense, the government is not abolishing the jury, at least not today. And the member for St. Joseph was carrying that type of argument and speaking about the problems associated with jury trials, as if the government was today asking us to abolish jury, trial by jury. But they are not. What they're saying is, look, we have an election where a defendant or an accused person can opt one way or another. As to whether or not that will be a first step in the final abolition of the jury, we don't know. But we certainly are not in the position today where we are abolishing the jury. But some of us feel that it is, even when you give this election and you're prepared to give persons the right, so to speak, that is problematic in the circumstances that we face. And the leader of the opposition was correct that you have to be careful in the context of what is happening in the country today with the perception. You know, Madam Speaker, everybody is want to do perception studies on politicians and political parties. Whether it's election or not, everybody want to do, how do people perceive the government, the opposition, Minister of Education? How are you perceived? Everybody want to do perception poll. But I don't know, people do perception poll. How do you perceive the judiciary? How do you perceive your chances at the magistrate court? What do you think of this? What do you think of that? So persons can give their view. And that might be something useful. My friend from Laventille West made an interesting point, you know. I think he confessed somewhat that he spent some time in Britain, and said that where the jury was removed, it was done partly because of, but not only, but partly because of the threat of the IRA and terrorism and so on, where there was a problem where persons who were going to be impaneled in a jury may have had some sensitivity towards issues. And you're not in your seat, but I don't know if it's proper for him to reply from there. But why don't you get to your seat and I'll give you the opportunity. Madam Speaker, I mean, we must conduct ourselves properly. Madam Speaker, so the member sought to advance this notion that it was done in Britain, because of that IRA condition. Now, is the member of the government suggesting that we have a similar condition here? Because we have heard of cases, I have heard, where members of the jury would report that they are conducting a matter in Port of Spain or wherever. They go to a gas station to fill their tank at some hour. A gentleman comes up to them and says, "How are you? You don't recognize me? I know you. We have a matter on X, Y, and Z." And, you know, there was a complaint once. I mean, I will not call any name of anybody, but there was a complaint once to the Toronto Police Service from someone as a sitting juror. And it came to my attention in another capacity for another reason. And it was terrifying, that matter. The government also came into office with a sort of promise that jury tampering was an issue. Unless I'm mistaken, that issue of jury tampering was found its way into policy documents of the party or the government. I could be wrong, but I think they were concerned with that. We haven't seen, to my knowledge, a bill or legislative measures to deal with jury tampering. So is it there's a policy change in the government now? Is there a policy change where you come into office to say, we want to deal with jury tampering, but we change our mind on that. Let's just move the jury out. So we don't need to deal with tampering of jury. Let's get rid of the jury. Is that a policy shift that we have seen in 20 months from the administration is a question I would ask. Madam Speaker, a lot has been said and a lot of weather made on this judgment and this matter the opposition leader introduced in the debate. And the member for Laventille West did spend a considerable amount of time in it. And I don't want to spend so much time, but just want to raise two matters related that the Attorney General or anybody else. Again, Madam Speaker, when I do these things, I ask for clarification. I ask you to clarify, not to buff me up, but to clarify, you know, because sometimes my colleagues opposite, when they respond after me, they really seek to buff me up for raising a matter rather than clarifying a point that I innocently ask you for help. Huh? The member for Laventille West took the time, as we say in local language, to gallery, you know, to gallery that the opposition leader raised a matter of this, the case of Jason Bissessa, and it was at first instance, and the matter was appealed, and the Court of Appeal ruled on it, and so on. I wanted to ask my friend from Laventille West, and others will speak after him, I believe, equally well qualified as he is on this matter. But you see, I also had an opportunity to look at this Court of Appeal judgment. The matter, incidentally, is a Court of Appeal matter of 2010. It's very instructive in the crosstalk during the opposition leader's presentation, when the opposition leader said, you ought not to be amending what is deemed unlawful. You should be amending that part of the Act, the Criminal Procedure Act. The Attorney General told her, why didn't you do it in the 5 years you were there? Okay. My friend, at this hour of the night, and given the condition of the government, now I will take your word. He did not say it. But I heard someone say that why, when you were there, you didn't amend the bill. But, Madam Speaker, I put it to you that not even members of the government knew that this matter was under appeal in the Court of Appeal. Because in the other place, this matter came, and we were not sure the government was aware of it. But in any event, it was 2010 appeal, and it was determined, I think there's a date here, Madam Speaker. What is it? 31st, yeah, the Attorney General, and I can say that you say so, says that it was determined the 31st of January 2017. But at number 39, at paragraph 39, I just want to read very briefly from a couple matters, because the member for Laventille West, I was waiting for him to read this, but time did not permit him to read this. Time did not permit him to read this. So it says, the state of the evidence has driven me to conclude that there was no effective system set up for the discharge of the appellant from the hospital, whether by way of review per se or by way of a procedure to facilitate any recommendation made by the tribunal for his discharge. No explanation was forthcoming from the executive. I find as follows: the appellant was entitled to a periodic review of his fitness to take his trial during the entire period of his detention. This entitlement arose as a common law right, and secondly, implicitly from the nature of the order by the judge. Such a right of periodic review included the right to be told of the outcome of any such review. This is consistent with the requirement of Section 5 of the Constitution. On the evidence, unsatisfactory though it was, the appellant's case was reviewed by the psychiatric hospital and so on. The failure to conduct such reviews was a breach of the applicant's right to the protection of the law and to such procedural provisions necessary to give effect to his constitutional right. So the Court of Appeal held that the right of the appellant was breached. That is the point. The right was breached. And the Court of Appeal said the failure to inform the appellant of the results of review and so on was a breach of the appellant's right to the protection of the law and to such procedural provisions necessary to give effect to his constitutional rights. This is on the evidence the appellant was fit to take his trial in October. The absence of such a system, and this is the link to the Criminal Procedure Act, Section 67, the absence of such a system was a breach of the appellant's right to the protection of the law and to such procedural provisions necessary to give effect to constitutional rights. Madam Speaker, I find that to be extremely critical, because what it suggests to us is that whereas the Court of Appeal may have ruled that there was no breach of the separation of power principle, they ruled that the appellant's rights were breached, constitutional rights, which remain in the Act itself, which remain there. This is why, Madam Speaker, and I want to just put on the public record, because a lot have been said today, the court ruled, the Court of Appeal, that the appellant is entitled to compensation for the breach of Section 4B and 52H of the Constitution. And the court ruled, I assess those damages at $100,000. So the appellant actually got damages. So it was a case where the Court of Appeal said there was no breach of that principle of separation of powers, but that section of the Act breached the constitutional rights. That is the issue. So when the leader of the opposition made this point, it was that you ought not to be amending by putting judge alone, tag on to Section 67, because the effect of that is to continue the breach of rights of citizens. Not the separation of power issue which the Court of Appeal ruled on. And this, and you know, this is the point we are making. Now the matter, I understand they have already gotten what is called conditional leave to go to the Court of Appeal. There's another process locally that is next. To go to the Privy Council, sorry. And the appellant. But they have conditional leave, and there's another process coming up soon. I don't want to get into that. But the issue here is that the Court of Appeal also ruled that the constitutional rights of the appellant were breached and granted damages. And they were breached pursuant to Section 67 of the Criminal Procedure Act. But they were not breached on a separation of powers. That is the... All right, so we got Laventille West giving the outgoing Minister of Public Utilities telling us that, but didn't complete the story. Because I really think time ran out on him. He had already spent 40 minutes on this matter. Madam Speaker, now again, you can dance left, you can dance right, and so on, and you could continue doing what you do, but the matter is still, or ought to be still, since a leave was sought and conditional leave was granted, that is a fact. The matter is still within our legal system. It is the subject of litigation. Should we then be coming to the Parliament to amend an act and amend a section of an act that is currently being litigated? That's the issue. And the opposition leader suggests, no, we agree with her. We agree with her. The member for Laventille West clearly don't agree with the member for Siparia. Incidentally, I want to remind Laventille West that prominent senior counsel Pamela Elder is on record as saying that if juries are abolished, she will burn her robes. I wanted to ask Laventille West whether he will want her silk as well, you know, whether he will call for her silk as well, or her robes. So, Madam Speaker, I don't want to engage Laventille West, who is sitting in Diego Martin Central and provoking me at this hour. Madam Speaker, well, maybe he is the Minister of Sport, we don't know. And he got a sniff of that and went to the appropriate seat. Madam Speaker, the speakers before spoke about countries where we have judge-only trial and so on. Right? They spoke of that. Judge-only trial. And we agree that we must do all in our power to fast-forward the administration of justice, to ensure that persons brought to trial quickly are either convicted or acquitted in a reasonable time. The opposition is on record as supporting that. Madam Speaker, may I remind the population that when we met the Prime Minister for crime talks almost a year ago, that matter was raised and we discussed matters at the Forensic Science Center. We discussed matters of legislation. We discussed matters of parliamentary oversight over national security. So we are interested in the administration of justice. Madam Speaker, just today we learned, I believe, of a mother and a 12-year-old boy brutally murdered in Malabar. We extend condolences to their loved ones, and as we do to all victims. But this is the state of the country today. A 12-year-old boy and his mother, I believe, brutally murdered today. So we stand, your constituency, is it? The babysitter. Or the babysitter and the 12-year boy brutally murdered today. Well, whether it's babysitter or mother, I think you still share the compassion. I don't think you want to do that. So we are interested in this matter. And my colleagues then raised the issue of judge-only trial, and I think it was St. Joseph who did that. And it happens all over the world. It happens in Singapore, I heard. It happens in Holland, I heard, Dutch. It happens elsewhere, member for St. Joseph. But there's a concern we have about this comparative advantage across the world. The member for St. Augustine, I think, raised one matter, following on Siparia. You see, Madam Speaker, we live in an environment now where it's very interesting what is happening here. A backbencher in the government and in the opposition, and I imagine a non-executive office holder in the government, and we have, at this moment, we have 3, we may have more or different ones by nightfall, by the midnight, but a backbencher in the government or in the opposition, all of us are under the integrity in public legislation. I know some colleagues opposite have a difficulty filling out and getting what is called a certificate of compliance. Madam Speaker, a member of the opposition as a backbencher has to declare all their assets, liability, this, that, everything to the Integrity Commission. They participate, or we participate, in no executive decision making. We monitor no state agency. We are involved in nothing involving public revenue except the expenditure on our parliamentary office. And that is monitored by the parliament as a unit to deal with that. So we spend no money. We do not have to account for state money outside of our parliamentary function. But a backbencher and a front member too of the opposition, because we don't hold office here, any office, and a member of the government who is not a minister of government as well as ministers, have to account to the Integrity Commission. But in our system, how it is that members of the judiciary do not. They do not fill out the forms, they do not declare assets and do not declare all properties, do not declare anything. And the person, and I cast no aspersions on any member of the judiciary, I'm saying from the public perception, those persons sit in judgment, and now, given this law that the government is intent on passing, and they may well do, it requires a simple majority, will now provide a situation where a defendant or an accused person can opt for a judge-only trial. And that person, from the perspective of perception of the public, sits now to determine matters that may involve, I can say, matter involve drug lords, multi-million-dollar, billion-dollar matters involving narcotics. You still want to ask me something, but you promise to make sense?
You're just rude.
Okay.
It's either you're giving way or you continue to direct your contribution this way.
It may not be his best day, I give him way.
Thank you very much for giving me. You don't have to be rude in order to do that. Yes. Honorable member, are you not aware that judges who sit in the civil court deal with the same categories of persons, though not criminal matters? And therefore, this question of bribing judges, which you are alluding to, is really not new. It depends on the integrity of the judge. And so far, apart from a magistrate, we haven't had that trouble here.
Okay. Thank you very much. I want to tell you, apart from a magistrate that you found out, you don't have that trouble here. Right? The point I'm making, whether it's a civil or criminal branch, is that with this legislation now, you are saying that there's an election by an accused person to say, I want a judge, no jury. Now, this will be a breakthrough. That person, and I cast no aspersions on the person. I don't like the member telling us and saying that I'm casting aspersion. I'm not. I'm saying that that person will now sit and determine matters that involve properties and millions and maybe billions of dollars and so on, and susceptible, and or should we not be thinking?
Standing Order 48.8, I think that point has been made in several different ways, so I'll ask you to move on, please.
Madam Speaker, I will not speak about the judges in Trinidad. Could I just put on record that in the United States, for example, Madam Speaker, in the United States, judges do post order forms on the internet, federal judges. There are systems in place, Madam Speaker, in the United States for declaration of assets for under the legislation in the United States. There are provisions, Madam Speaker, that judges will declare, yes. The Ethics Act of the United States, Madam Speaker, requires annual disclosure of financial information by the President, Vice President, members of Congress, federal judges, and others, and I don't want to quote the others. That is the situation of the United States. So we talk about countries where they use judge-only trial. And Madam Speaker, we have it for Ecuador, we have it for Bulgaria, we have, you know, in other countries, we have as well, I'm looking here at the United States, I see also, you know, in fact, Far Eastern countries, in Europe and on the Eastern European side, Lithuania and so on, persons are required to declare private interests, including politicians, civil servants, judges, military professionals, and so on. We have disclosure of assets made by judges, Argentina, the United States, South Africa, you know. And could I just say South Africa, because I'm looking at Commonwealth as well, not just across the world. Until 2008, there was no law that required judges to submit declaration of their assets. In 2008, Parliament amended the Judicial Service Commission Act 1994 to provide a mechanism for judges to disclose their registrable interests as well as that of their spouses and dependents. And this is South Africa, Madam Speaker. And we have as well, because I'm just searching out Commonwealth areas as well. Oh, sorry.
Your 30 minutes have now expired. You're entitled to 15 more minutes. Please proceed.
Yeah, thank you, Madam Speaker. Kenya, you know, Kenya, which shares some similarities with us as well. They also have legislation where judges are required to disclose assets under the relevant act in Kenya as well. So you have Kenya, South Africa, United States, elsewhere. And if more research is done, I'm sure we will find many other countries. So, Madam Speaker, the point really is that if you attempt to change our system in this way, where you present a case for judges-only trial, should we also have a discussion on having members of the judiciary under the Integrity in Public Life legislation or any other suitable body of law that one could have some confidence that they are, you know, suggest they are, you know, giving information as it regards to that matter. Madam Speaker, Madam Speaker, now of course in the Attorney General opening presentation, he took root, his argument took root among other areas by the statement of the Chief Justice. I think my friend from Caroni East quoted extensively from a presentation by Senior Counsel Israel Khan, in which that matter of the Chief Justice arose. But I would like to remind the Honorable Attorney General, the member for San Fernando West, that he rooted his argument today on the call by the Chief Justice to make this type of change regarding jury system. But the Attorney General will not act on the judgment on a minority opinion of the Chief Justice and others on the Surat matter to go to the Privy Council to clarify the state of the law as it regards that matter. So there is a point in which it's convenient to lean on the Chief Justice today for this argument. Madam Speaker, Madam Speaker, I seem to have dealt with a few matters I want to raise, and really winding up, I have nothing else really. But to say that I've asked for clarification, I've asked for clarification.
I'm sure.
Oh, sorry.
Member for Oropouche, I'm sure the Hansard has your presentation, so no need to summarize. You have a few more minutes left. You can make it if you have other points to make.
So, Madam Speaker, I have nothing further to add to my well-structured presentation here. But to close, and member for Laventille West is still speaking even at this time when the Prime Minister has already used his ink on you. So, Madam Speaker, I will ask the government to be cautious about, Madam Speaker, but you know, I think he is excited.
As we said earlier, you know, let's keep our passions within certain confines. Please continue, Member for.
Yeah, thank you. So, Madam Speaker, the Attorney General is one to tell us that this is part of the architecture of change. It is one piece of a puzzle that the Attorney General and the government want to put together to deal with the administration of justice. As the member for Point Fortin would say, it is part of the menu that they are putting forward. But it is something that we want to warn the government today to be cautious. It was a former Prime Minister and President, whether you like him or not, who spoke about streams running into rivers and rivers running into the ocean, whether you like that or not. But when you put all these pieces of puzzle together, you might get a picture that you do not like. And it is a picture of punitive measures, it is a picture of fines, it is a picture of legislation that comes without proper consultation with the national community, but change occur, and change will occur. It is that picture. I heard my friend from Caroni East speaking a little while ago, and when he was speaking there, I remember it was in Stalin's time in Russia, Madam Speaker, where there were certain fines where if you were walking the street and your boots was not shined properly, if you didn't have a shiny boots and you walked the streets in Moscow, there was a penalty for that. There was a fine. There could have been an imprisonment. You could have gotten your death warrant signed by standing up to the secret police. These are matters that we must take stock of, and don't try to push the envelope too far on the table. It will fall, and in falling, you may have repercussions that you will not appreciate. Madam Speaker, I thank you.
Member for Port of Spain North, St. Anne's West.
Thank you very much, Madam Speaker. Madam Speaker, right-thinking citizens of Trinidad and Tobago, once again we put things into proper perspective and into context. We've heard a lot today, and a lot that could lead persons who are listening on to believe that this bill, and in this particular piece of legislation, is something that should be feared. We've heard the suggestions starting from St. Augustine, and we just heard from Oropouche East, that this is the start of something. Madam Speaker, this, as we've just heard Oropouche East say, is one of the spokes of legislation being brought by this government to improve the criminal justice system. And on behalf of Port of Spain North, St. Anne's West, we would like to applaud the Attorney General and his team and my friends who have contributed on this side and even some on the other side for supporting legislation that has one simple purpose, Madam Speaker. Forget all of the fear-mongering, forget all of the suggestions and the speculation as to what may come in the future. No truth to that whatsoever. Legislation has been brought to this House in this session to improve the criminal justice system. This is yet another piece of that legislation. That legislative agenda is another piece of the, as we hear from my colleague from Point Fortin talk about the architecture. This is all geared towards improving the criminal justice system. Another very, very important point that I'd like citizens to understand, Madam Speaker, is despite all that may have been said, this is elective. This is not a step being taken by the government to abolish jury trials in Trinidad and Tobago, Madam Speaker. Madam Speaker, this is an elective process where a person on an indictable offense, which is an offense that is heard in the criminal assizes of the high courts, has a choice. And it is important that persons understand that. The accused has a choice as to whether he or she wishes to have their matter heard by a jury and a judge or by a judge alone. So jury trials will continue. This is a step in the right direction. It is very important that everyone understands there's no abolition of the jury system. Again, Madam Speaker, as was decided on the 7th of September 2015 by the population, let the population take note once again as to what exactly is before this House for vote in a short time. And let the population, in looking on, understand very clearly what this bill seeks to do. And having said that, Madam Speaker, I'd like to just very briefly remind the population as to the origins of a jury system. and what jury trials came from. And they really were developed as far back as the 8th and the 11th centuries by the Maliki school of Islamic law, Madam Speaker, which operated in North Africa and Sicily, called the Lafif, a body of 12 men drawn from a neighborhood who would get together. They swore to tell the truth, Madam Speaker, and give a unanimous verdict about matters they'd been asked to rule on. Jury trials, Madam Speaker, were first introduced in Trinidad and Tobago by Ordinance 11 of 1844. The Jury Act, Chapter 653, provides a legislative framework, Madam Speaker, for jury trials. Persons are very familiar with the mode and effect and how a jury trial is conducted. It's a matter where a judge is sitting, listening and guiding with respects to the areas of law in a criminal trial, and where 12 members of a jury for capital offenses, 9 members of our peers drawn from civic society and citizens of Trinidad and Tobago come forward and listen to facts, and at the end of a trial are asked to determine on the facts whether someone is guilty or not guilty. That remains in place. The Attorney General has quite rightly seen it fit, and despite what was said, I believe, by someone on the other side, I can't remember exactly who it was now, I think it was Chaguanas West, they threw words at the Honorable Attorney General saying, come here with facts, come here with data. Madam Speaker, once again, those are hollow, shallow words with no merit and no substance behind them, because this is the first Attorney General, certainly within a very long time, definitely over the period of the last 7 years, who has actually brought data to the Parliament. He's gone. He's taken his time, Madam Speaker, and done the data-driving and gathering of the prison system. We now know how many prisoners there are, who's on remand. We now know how many the backlog of the criminal justice system, as we heard with previous traffic offenses, how many are clogging up the system. Madam Speaker, the election of whether to, as an accused, to have a judge-only trial, as we've heard being admitted here this afternoon, despite what was originally said by the Honourable Member for Siparia and the shots that were taken previously at the constitutionality of this bill, the Honourable Member of Siparia stood up during the contribution of the Member for St. Joseph. Yes. So,
thank you very much, Madam Speaker. Madam Speaker, in accordance with Standing Order 15.5, I beg to move that this House sit until the conclusion of the business before it this evening.
Honourable members, the question is that the House continue to sit until the conclusion of the business before it. Those in favour say aye. Aye. Any against? The ayes have it. Member for Port of Spain North, St. Anne's West.
thank you. Thank you very much, Madam Speaker. Madam Speaker, the point that I was making was that you still have the opportunity as an accused to elect whether you want a jury to hear your trial or not. The benefits that can be derived will be effected. We will experience them of having a judge-only trial. We'll be able to gather the data, the statistics. People will be able to see the benefits for certain matters of not having a jury in their trial process. And that is something to be commended. Madam Speaker, at this point, I would like to refer to the opening address of the head of the judiciary of Trinidad and Tobago, the Honorable Chief Justice, from the 2015 to 2016 law term on September 17th, 2015, where the Honorable Chief Justice, Madam Speaker, made a plea that was directed at the citizenry of Trinidad and Tobago with respect to jury trials. And if I may, he stated at page 9 of his address, Madam Speaker, about 15 to 20% of sitting time is lost.
1B. The Attorney General said that earlier in the day.
Member for Port of Spain North, St. Anne's West, please continue.
Thank you very much, Madam Speaker. about 15 to 20% of sitting time is lost owing to jury management issues such as illness, exams, family funerals, lateness, etc. And this does not include the time we spend traipsing them in and out of the courtroom every time counsel wants to make a legal submission. At the end of that, there are a significant number of hung juries, which mean we have to start the whole thing over again. And this, Madam Speaker, of course, is the Honorable Chief Justice, the head of the judiciary, who's in charge of the administration of justice. He continues, Madam Speaker, now in 2016, 2017, the opening of the law term on the 16th of September 2016. So after the plea, Madam Speaker, that the Chief Justice made with respect to jury trials in 2015, he comes again in 2016 and he says at page 22 of his address, quote, while it is true that 185 accused persons had their indictments dealt with, 75 of those, or 41%, had retrials ordered so that their matters were simply recycled into the system. Simply put, and Madam Speaker, the Chief Justice in his speech now put this part in bold and in caps, the jury system is not working. So, Madam Speaker, we have the head of the judicial system with the support of his judicial officers pleading to the country, and the only time the Chief Justice and the judiciary have to speak to the population in an open setting is at the law term opening. So anyone who has practiced law, those of us who have practiced in the courts, know that the tradition is the voice of the judicial system is always the voice that comes from the Chief Justice at the opening of a law term. And he is pleading. In times past, the Chief Justices have asked for financial autonomy. They've said that there's been incurrences on the independence of the judiciary, etc. This Chief Justice has seen it fit in 2 back-to-back settings of his law term speeches to tell us about the jury system. He goes on, I don't know how many times I have to make the point to those who have no understanding of how it works, that if matters are heard by a judge alone, he or she has to make a decision one way or the other that is definitive and subject to appeal.
Excuse me. I just want to remind members of the provisions of Standing Order 53. I want to hear the contribution for the member for Port of Spain North, St. Anne's West. Please continue.
Thank you very much. So, Madam Speaker, the Chief Justice is pleading, and he's pleading to us in the legislature, because we are the ones who can take heed of the calls of an inefficient criminal justice system and make the changes that the Honorable Attorney General has been doing. So this is a government that is listening to not only the users of the system, but we're listening to those who are in charge of the system, because we, the 41 members in this house here and others in the other place, have the responsibility, the constitutional responsibility, Madam Speaker, to change the law, to amend the law, to make more efficient systems, including a criminal justice system. So, Attorney General, thank you. Thank you for the suite of legislation that you've been bringing.
Yes, ma'am. That is easy.
Thank you for improving the criminal justice system, despite the cry of wolf by some others here in this house. And I'll come to that in a short while, in particular the contribution of Chaguanas West, that I sat there and I wondered to myself, because he has participated, the member for Chaguanas West, in litigation in the High Court system. So they must know how it operates. And here we have, Madam Speaker, getting back to my point, if you would permit me, and to the Chief Justice, the Honorable Chief Justice, pleading with the nation, and in particular us, those 41 of us who are elected, and part of our duty is to amend the laws, to bring legislation, and this is good legislation. We've had an opposition come here today, initially attacking the constitutionality of the bill, and all of a sudden whittled down because a senator was seen hush-hush in the corridor saying, hey, don't go down the road of that constitutional argument, you know, because look the law here, all you're making a mistake. The most hasty retreat we've ever seen, none other by Siparia, jumping up in the middle of St. Joseph's contribution to say, we have no issue with the constitutionality of the bill after her whole contribution attacking the constitutionality. Let the population of Trinidad and Tobago take note. Madam Speaker, back to the Honorable Chief Justice. I don't know how many times I have to make the point to those who have no understanding of how it works, that if matters are heard by a judge alone, he or she has to make a decision one way.
Member for Caroni, may I hear your point of order?
Yeah, 48-8.
Please continue, Member for Port of Spain, North St. Anne's West.
Thank you very much, Madam Speaker. It's amazing how those on the other side always seek to stifle the truth being told in this House. And again, I put down a marker. Right-thinking citizens of Trinidad and Tobago.
Standing order 48-4. How we are trying to suppress the truth.
Member, could you just state that in another way? And please continue.
Thank you very much, Madam Speaker. Those on the other side seem to become quite nervous when the truth is falling from this side. Heard by a judge alone, he or she has to make a decision one way or the other that is definitive and subject to appeal based on a consideration of transparent written reasons, none of which applies to juries. Correct. So the Honorable Chief Justice is telling the population that the only opportunity that the judiciary has to speak to the population, including the 41 members of this House, get rid of the jury system because it is actually improving the criminal justice system. And actually, you know what? It takes away the uncertainty of a jury system because a judge is someone who is trained and capable and actually, as this legislation proposes, has to give reasons. How can any right-thinking citizen, and in particular a person who is accused of a crime, Madam Speaker, have a problem with a judge having to give reasons? Your 12 peers, your 9 peers now who sit on a jury do not have to give reasons. This is an improvement in the criminal justice system. So it pains me, it literally pains me, Madam Speaker, to have to sit here and to hear once again attempts being made to mislead the population. So the Chief Justice continues, he says, if the current inefficient and ineffective system is what the country wants to have, then fine, but don't blame me for the consequences. I was appalled at the conclusion of a recent matter that occupied a court for over 2 years to hear the bleating about the vindication of the jury system. Of course, for those who are acquitted, one can well understand the sense of elation. But what about those who have to be retried? Madam Speaker, there is no clearer language for a call of responsibility by those who make the law than to hear the cries of the head of the judicial system and the criminal justice system asking, pleading, saying, we're dealing with an inefficient system, please fix it. And what does this government do immediately? It comes to the House, and it came to the other place, with the legislation to fix it. Those on the other side who scream and bawl, one man, one this, one that, let the population judge them now. We are fixing what the judiciary has asked, as I've just quoted from 2 back-to-back opening of law term speeches. This government is fixing it. This government will fix the inefficiencies of the criminal justice system. And Madam Speaker, what is so ironic is that persons who may be subject to a criminal justice system may be the beneficiaries of that efficiency that we're trying to create. So there may be people who very soon, Madam Speaker, will be the subject of the criminal justice system and they will thank us.
48-4, that is threatening language.
Who is threatening?
Who threatened?
I would ask all members to watch their language. I rule that there's no merit in the point. Member for Port of Spain North, St. Anne's West.
Thank you very much, Madam Speaker. Madam Speaker, that point was related to those who face the criminal justice system. That point is to those who are accused and charged and come before a criminal justice system. That point was not directed at any member in this House that I am aware of who may be before the criminal courts. We are trying to create a more efficient criminal justice system. Respectfully, we are immediately actioning the cries of the judiciary and the judicial system and an area of great inefficiency. The Chief Justice continues, are they the victims' families not entitled to some finality in determination of guilt or innocence within a reasonable time? From a management process justice or simply a common sense point of view, any proceeding that occupies so much time and resources without producing a definitive result is a total disaster. That is not a criticism of the judge who had to manage an extraordinarily complex trial, nor of the jury who, untutored in the principles of law and evidence, had to sift through mountains of evidence and complex directions. It is a systematic failure that this is the Chief Justice and the judiciary, do not have the power to fix because I do not pass legislation. We do. Let us fix it. What can be the opposition to not an abolition of the jury system, Madam Speaker, but the provision of an elective basis where an accused can choose to have a judge only hear his or her trial? We have heard absolutely no reasonable suggestion as to why that shouldn't take place. And on that point, Madam Speaker, I would like to address a few issues raised by the member for Caroni West, Chaguanas West, sorry. I could not believe this was falling from his lips. He told the Honorable Attorney General, this is an inopportune time for this type of legislation. He said, having regard to what is happening right now through the judicial system, this is an inopportune time. Madam Speaker, absolutely no merit in that submission whatsoever. This is the time. In fact, the time was 6 years ago. The Chief Justice has been pleading the judicial system, anyone who practices in it, and my friend from St. Augustine should know, because he, out of everybody in this House, is the one who has practiced the most in the criminal justice system, along with my honorable friend from Laventille West. And they know, the honorable member for Toko Sandy Grandi has also seen what is taking place in the criminal justice system. And she supports this legislation. Madam Speaker, I've taken the time, respectfully, to tell the population of Trinidad and Tobago that this government is being a responsible and responsive government. Not only hearing, but reacting positively and in a productive manner to the clarion cry of the judicial system that is screaming and crying out, saying there are inefficiencies that can be fixed by legislation. And rather than us sit and listen and do nothing about it, we have brought this piece of legislation.
That's right.
Well, so, Madam Speaker, I commend the government. And I commend the Attorney General once again for leading the charge. I mean, all the other pieces of legislation, we've heard some members have the audacity to challenge and to laugh and to try and ridicule talking about a suite of legislation. Yes, as a government, we have brought a suite of legislation. And Madam Speaker, this government will continue to do what is right for Trinidad and Tobago. Madam Speaker, this government will continue to take the difficult decisions, not only with legislation, but in other areas, as we do on a weekly basis. And we will do what is right for the future population and the future generations of Trinidad and Tobago. And this is yet another spoke in that wheel of inefficiency. And we will stand proud, and we will stand brave and without fear to carry out our oaths of office. And we will do what is right. And we assure the population that we will not bring legislation that is unconstitutional or trampling on anyone's rights, as we heard quite embarrassingly so, admitted after a full 40 minutes by the member of Siparia. Another submission made by my friends on the other side I'd like to deal with, Madam Speaker. Chaguanas West said, tailor legislation that is appropriate. We did. So come now and let the population call upon everyone in this House to support that tailor-made legislation. He said this is delay legislation. It is quite the opposite. And again, Madam Speaker, I remind the population that this is elective. This is an elective process. We are not doing away with anyone's rights. We're adding rights. He had made the point about have to be a more data-based Attorney General. There has not been an Attorney General within the last 7 years who's brought that much data. The audacity of the submission that this legislation will not impact upon the backlog. Madam Speaker, we've heard from the person in charge of reducing the backlog that this is the type of legislation. Madam Speaker, throughout the English-speaking Caribbean, there actually was a distinguished jurist lecture and panel discussion on the continuing relevance of the judiciary system in the English-speaking Caribbean, held on the 11th and 12th of June 2013. So the cry was coming from as far back as June 12, 2013. Justice Jacob With, a CCJ judge, Madam Speaker, made the following point, if I may quote from his submission, from his talk on the panel. He said, as a former judge in the Netherlands, where jury trials do not exist, he strongly advocated for non-jury trials, describing it as a system that does not work in Trinidad and Tobago. He said, in response to the proposition that juries are part of a democratic society, Justice Witt said the following, Madam Speaker. When the Trinidad and Tobago government, some months ago, announced a plan to abolish trial by jury, hold on. Madam Speaker, this is in 2013. The government at the time, with those on the other side, this is a CCJ judge saying that the government of the day, i.e., those on the other side who are now in opposition, announced a plan to abolish trial by jury. But now they stand here in this House and other places and say they want to oppose an abolition of trial by jury. But again, we are not abolishing jury trials. We're providing accused with an election as to whether they want a judge-only trial. He went on to say, replacing it with a trial by judge alone or a bench trial. Several attorneys reacted as if stung by a wasp. We've had that recently. Senior practitioners at the bar screaming and shouting, if you abolish jury trials, I'll do this and I'll do that. The question should be asked, why? Why would any member of the bench not want their client to have the opportunity to elect, the opportunity to choose whether they have a jury or not? And the legislation is good legislation, Madam Speaker, because when we go to it and when we look at it in committee stage, we will see as legislators, we are putting in place certain safeguards that an accused cannot just elect, I don't want a jury. They have to get legal advice. They have to submit that legal advice, the fact that they've gotten proper legal advice to a judge who then has an ultimate discretion or not. So there are protections in place. There are forms in place that must be statutorily sworn to. So all of the protection, and again, Madam Speaker, to the population of Trinidad and Tobago, we've heard not a single reason here this afternoon as to why this legislation should not be passed. Not a single person has been able to point at a specific clause in this legislation and say in any convincing manner whatsoever that this is bad legislation and should be corrected by X and Y, and then we shouldn't proceed with it. Madam Speaker, I've dealt with the elective point. We talk about consultations. I want to put on record here, please, Madam Speaker, through you tonight, on the 28th of June 2017 at 8:08 p.m. That is a red herring. We talk about consultations that is thrown time and time again out at us as a government is a red herring. What is the need? And the Attorney General will address this in his winding up, because I don't have the answer, but I'm sure that there was a level of consultation done. But even if there wasn't, this is not the taking away of anyone's rights. This is actually the provision, Madam Speaker, of a new right to persons. So what must we consult on? You want a new right? That makes no sense. There's a cost to consultations as well. There are certain areas where consultation should take place, and every responsible government will do, as we did recently with the children marriage bill and act. He went over and over and over for consultation. Tobago, South, North, everywhere. Local government reform. We had 14 consultations. That legislation is coming to the House shortly. So, Madam Speaker, I don't want to keep us here much longer. The simple points that I'd like the population to go away with are that this is good legislation. We're giving accused persons more rights than they currently have. They now have the ability to elect whether to have a judge-only trial. We're not getting rid of juries. This is actually a good pilot project. This is one spoke in the wheel of making a much more efficient criminal justice system. And I dare anyone to stand in front of the population of Trinidad and Tobago when they're facing issues of crime on a daily basis and tell them there should not be a more efficient criminal justice system. So, Madam Speaker, I stand here as elected member for Port of Spain North, St. Anne's West, and I commend this bill to all of the members of this House here tonight. And I say without fear of contradiction that there is nothing wrong with this legislation. This is good legislation. This legislation answers the call of the judiciary for there to be a fixing of a system that they are telling us is inefficient. And Madam Speaker, with those few words, I support this legislation.
Madam Speaker, I intend to be brief on this bill. I want to say very simply that it is not true that the last government, that is to say the government of which many of us on this side were part, that we at any time contemplated the abolition of a jury trial. The matter did come up for discussion, and we participated in the discussion. And we engaged the issue. And at times, I remember, and it might have been at least 3 times, it might have been 4, around the cabinet. On each occasion that it came up, the matter was very contentious, and people had very strong views about the matter. The second thing is that I want to remind the member for Port of Spain North, St. Anne's West, that this is a parliament, and that the purpose of being in parliament is to debate the bills that come here. And the government side cannot expect that when we come to debate a bill, whether we are going to support the bill or not, that we will stand up here and say to the government, this is a great bill, and therefore we have nothing to say. We are going to vote for the bill. That is not the way the parliament works, and that is not the role of the opposition. The role of the opposition in this House is to highlight concerns. Those concerns may be concerns that derived out.
Member for Caroni Central, please continue.
Madam Speaker, the role of the opposition is to interrogate the bill and to raise concerns that are important to it. Those concerns may come out of an intellectual examination of the bill. It may come out of the engagement by constituents on matters of concern about the bill. Some of it may be on the basis of facts in the bill. Some of it may just be on the basis of feelings, things they may read in the newspapers, etc., things they may raise as fears, or things that they may simply speculate upon, but they raise it to you. And while you may engage them and you educate them, it is important for that constituent to know that you have listened. And the way they know is because you have come here and articulated some of their concerns. It is also, this matter is not a matter that is settled. And it's not a matter that is settled in every jurisdiction. And I remember when this bill first came here in this particular house, the choice that is given in this bill was not as clear as it is here today. When it came here, when this bill was first circulated, okay, the bill basically took the position that the jury trial was something that really was not progressive in the legal system. And as a consequence, the decision by a judge in a trial was superior. That was the argument. That was the thinking behind the bill. And it is only after it went to the Senate, it was interrogated, it was engaged, it went to committee, that the amendments were made to bring this bill back here. And the leader of the opposition pointed that out because it had moved by a number of pages from 8 to where it is now, which is, I don't know, 22, 23 pages, 24 pages. So basically, that is the situation. And I want to give the experience of the last 2 bills that came before this House. The marriage bill came before this House.
Member for Caroni Central, I will not allow you to go back to a matter that has been already engaged this House and been passed in this session. So you can continue to make your points within the time that you have, but please abide by that ruling. Thank you.
I simply want to make the point of 2 bills that we voted for, Madam Speaker, but bills, nevertheless, that we criticized during the course of the debate.
I think what I've said is quite clear. I'm sure you can make your point in another way. Please, I don't want us to go back to something that has been debated and passed. Please.
Well, we voted for 2 previous bills that came before this House, Madam Speaker, and we thoroughly interrogated that bill. We suggested amendments to one of the bills. They were not taken, and yet we voted for the bill. And the reason we voted is because there was enough substance in the bill.
3.
This is precisely the point I'm trying to make, member, so that if you can press on to your point, I think you've made on the foundation of what you've said already, I think you've made the point. Okay, but I do rule and uphold the objection under Standard Order 48.3, which is what I've been trying to stay you from.
Madam Speaker, all I can say at this point is that there was no need for the self-righteous tone of the member for Port of Spain North, St. Anne's West. I imagine self-righteous is now an unacceptable word in this parliament. But there was no need for the self-righteous tone of the member for Port of Spain North. All the members who spoke here, leader of the opposition, member for St. Augustine, member for Caroni East, member for Oropouche East, member for Chaguanas West. All of the members who spoke here, they spoke to the issues in the bill. They had a point of view on the bill, and they expressed that point of view. I believe it is reasonable for anybody who has to be tried in a court of law, if they are given the choice, to make that choice. I don't think anybody should. Well, why don't you let me speak, Madam Speaker? They are interfering with me.
Okay, I will just ask for temperance. Member for Caroni Central, what I would suggest is if you direct your contribution to me, you're very experienced members. I'm sure you can rise above the crosstalk, and please direct your contribution here. Don't be distracted. Your time is precious.
Madam Speaker.
Member, let's leave that. You use your precious time to get your contribution across. Please.
Madam Speaker, I wish to ask for your protection. I will direct my words at you. I do not wish them to direct any words at me. And I'm asking for your protection in that regard.
I would ask all members to respect the decorum of this House. I remind you of Standing Order 53. And please allow Member for Caroni Central to address his contribution and give it the respect it deserves. Continue, please.
Thank you very much. Thank you very much, Madam Speaker. I was making the point that the members acted within the best tradition of Parliament and made the points that they needed to by interrogating the issue. And I was also saying that anyone finding themselves in a situation, Madam Speaker, in which they have to go to trial and having had a choice, I think the choice should be a choice that they are able to make freely rather than have a piece of legislation, a law passed, curb the choice for them. I am not saying that this legislation does that. It does give them the choice, and in many clauses, it is repeated here in the bill before this particular House. And with that, we cannot have any quarrel. I think many of the contributions of members of on this side was simply pointing, first of all, to the flaws in the argument about the superiority of a trial in which the judge was the sole determinant, and on the other hand, making the case for a trial in which the jury of ordinary people, peers, made a decision, and they were arguing for the significance of that in relation to certain traditions within the British legal system and the British democratic system, which has been passed on here to Trinidad and Tobago, and which we have evolved. That is what this whole thing was about. We were not fighting with the government about anything. We were fighting the issues. And we wanted to articulate the issues so that the country would understand. We also wanted to say that there are certain things that are held as sacrosanct, but it is held, those things are held as sacrosanct only in certain circles and for certain reasons having to do with the evolution of this society. And those points were made, they were articulated, they were pointed out, and that is basically the argument that we were making. This bill, we do not find with the amendments that came to the Senate, from the Senate, we do not find it as objectionable as we found the first 8-page bill. And we make that very clear. It is very different, and we therefore are willing to engage the bill in a constructive way. In closing, I want to indicate Madam Speaker, I simply want to point out to you, because these issues come up all the time, that the members on the other side are simply provoking me. And now that is a joke for some members.
I want to assure you that no attempt to provoke any member by any other member would be tolerated in this House. Okay? So again, as I said, direct your contribution to the chair. You are experienced that you can rise above crosstalk, which you know is part of parliamentary practice and traditions. Please look this way and direct your contribution. You have the ear of the chair.
Yeah, I will simply close at this point. Madam Speaker, I've made the few points that I wanted to make, which is first of all to correct the record that we never intended at any time to abolish jury trials. Secondly, that Parliament is for open and free debate on the issues. Thirdly, that the opposition has a role to play in this Parliament, and the government cannot prevent us by anything that they do from playing that role of the opposition in this country. Thirdly, fourthly,
Okay, so member, if you could just restate that in a way that is not imputing any motive, and we can press on, please.
What motive did I impute?
After that speech is done,
Yes, member. Again, just restate what you just said, and please continue. I'll ask all other members to please again conduct themselves with a manner which is deserving of this House. Member Caroni Central.
I'm glad the members of the government heeded your statement today, Madam Speaker. I'm happy to see it in action. But, Madam Speaker, the role of the opposition is clear from our point of view, and we will not be hindered in any way by the government, either by their behavior, their actions, or the statements that they make, or their attempts to ridicule, to prevent us from expressing our view as the opposition and from presenting ourselves as the opposition voice in this country. We have the precedent of having criticized bills and voting for it, and therefore we choose to do that as is necessary depending on what the bill might be. Finally, there is no need for the government to take a position by any of its members, and in this particular case, the member for Port of Spain North, St. Anne's West, to seek to take a self-righteous position to berate the opposition for taking a position of their own. It is our right.
Okay. All right. So you've made the point, member. Please press on and let's. Member for Caroni Central.
It is our right to express our view, and we do not have the government has no right in this Parliament to chastise us for the views that we take. That is what we stand up in this Parliament.
Madam Speaker, Standing Order 48-6.
Member again. Please try not to impute any improper motives. As I said, you have a little time left. Please use it to your benefit.
Madam Speaker, in the time that I've spoken during this period, I must have been interrupted about 10 or 12 times. The Speaker's attention is not focused on the protection that I asked for.
Member, I am sure you really don't mean that in the way it sounds. And therefore, I would ask you not to proceed along that line. The chair will try as much to rise above that statement, but it's not going to be tolerated if it is continued.
Madam Speaker, you know at a point in time I asked for your protection. Is that correct?
Please continue with your contribution.
Yes.
Please.
Well, I simply want to say that we have made our contribution in this bill. We have said what we had to say, and we will vote as we feel that we should vote, given the conduct of the government in this matter.
Attorney General.
Speaker. Madam Speaker, I rise to wrap up this debate. I think importantly to actually get back to the terms of the bill. Because, Madam Speaker, most respectfully, I mean, in the very vacant seats across me now, the large part of the House, opposite, I really found it very hard to follow the opposition's views on this bill. Let me start with the response to the Honourable Member for Siparia straight away, because many of my colleagues have given good reflection on a number of matters. I note yet again the member for Siparia is not in the House to listen to responses, much like other bills where there were embarrassing positions on the part of the opposition. But I note in particular the attempt by members opposite to somehow scurry back to the point that the leader for the opposition did not make a comment on the constitutionality of this law. Let me read from the unrevised Hansard of the member for Siparia. However, Madam Speaker, I had planned. In fact, in our caucus yesterday, I said, look, our senators have spoken on this, and they have put in all these amendments. There was a special select committee and so on. So you know what? Tomorrow this bill should get easy passage. But after the caucus, when I finished my caucus and I got down to actually reading the bill, I cannot believe, after the rigorous process that the bill went through to reach here, the amendments, the level of incompetence being demonstrated, and this bill has some fundamentally flawed positions that we cannot do it. She then goes on, the Honourable Member, to touch on an issue of blacklisting, which I will come to separately, because the Honourable Member spent some considerable time talking about an alleged blacklisting of Trinidad and Tobago.
Madam Speaker, I'm standing order 55(1)B. This tedious repetition. This is the fourth time that I'm hearing this point about the political leader, the point he made. What's wrong with you? It was made by 4 speakers.
Thank you very much, Member for Naparima, Attorney General.
Thank you. Yes, Madam Speaker, perhaps the Honourable Member is not aware of what a wrap-up involves. But Madam Speaker, I have the Hansard from the Parliament, today's Hansard of the unrevised version of the Honourable Member for Siparia, and I am dealing squarely with the attempt to say something and then run away from it by the entire bench opposite. The Honourable Leader of the Opposition went on to say, I didn't hear him go into the changes to be made to 67 and 68. Now, it is mind-boggling that so much time was spent in the Senate on this matter. So much time was spent in a special select committee. The Honourable Member, went on to speak about man hours spent on the bill, etc. And the Honourable Member says, and I quote, the same fundamental error after all that time is being made with Section 67 and 68 of the Criminal Procedure Act. The honourable member then went on to quote, and I quote as follows, "I have to refer to the judgment on Madam Justice Pemberton as she then was, now elevated to Court of Appeal, in the case of Jason Bissessa, no relative pleas, versus the Attorney General, in which a very big deal, because you have brought sections that have been struck down by the courts, asking us to insert judge or delete judge and jury and add jury. This is a serious matter, and therefore I will give it to you in a second." And the honourable member goes on to cite the judgment as 2009-0410, judgment of the Honourable Pemberton between Jason Bissessa and who is the defendant? The honourable member says, the Attorney General. And this was delivered on the 11th day of June 2010. The honourable member then goes on to make a very important position on the part of the opposition. In this judgment, the court made it very clear with respect to 67 and 68. And you see, it is not a simple question of now removing these sections because you'd have to put in other provisions in place. But you did it because it was brought to your attention in the offences against a person, and the Honourable Attorney General at times tried to blame the Law Revision Committee, say that they didn't do their homework after the court had struck those things down by striking them down. She says this, the Honourable Member, "The Law Revision Commission cannot change the law." So here we have the submission from the Hansard, unrevised as it is, of the Honourable Leader of the Opposition of Senior Counsel, saying that the bill is fundamentally flawed. We then had Oropouche East, another member of the Parliament who has a habit of not being in the Honourable Chamber when we are wrapping up bills, particularly as he expects answers to come at him. But the Honourable Member for Oropouche East then says, "We didn't come here to talk about constitutionality, you know." But Madam Speaker, I listen to the news regularly, unlike the Honourable Member's self-professed lack of awareness on that. That's Oropouche East. And I heard 8 o'clock news, 9 o'clock news, 10 o'clock news, 11, 12 o'clock news, 1 o'clock news. Who was being quoted on the news? Oropouche East. We are not going to walk out of the chamber today. We will walk in, because there's serious constitutional issues to be dealt with. So Oropouche East and Siparia obviously had the wherewithal and mindset to make sure to speak to the media this morning, talk about serious constitutional issues. But Madam Speaker, what I found astronomical was that the members who support the research of the Honourable Member for Siparia could have set up a leader of opposition like that. And let me explain what I mean by that. The Honourable Leader of the Opposition had the wherewithal to come to this Parliament and distance herself from the man-hours spent by her own senators in the Senate, where there was unanimity of purpose and vote, no voices against the bill, and then make an observation that it just can't be supported effectively because of serious constitutional issues. Well, Madam Speaker, the minute I heard that, recognizing that the Honourable Member was talking about a 2009 case, with a judgment being delivered in 2010, we're now standing in 2017, and it was delivered in June 2010 when Anand Ramlogan was the Attorney General. The fact is, first of all, let us assume that the submission of the Honourable Leader of the Opposition was correct. The Honourable Leader of the Opposition's submission is, the law has been struck down. You can't amend law which is struck down. You made a fatal error. Shame on you. Number two, I just quoted from the Honourable Leader of the Opposition, who said the Law Revision Commission cannot amend the law. Madam Speaker, my God Almighty. That may be self-righteous perhaps, but my God Almighty, Madam Speaker, the Leader of the Opposition, Senior Counsel Kamla Prasad Bissessa, MPSC, TC, fails to realize that the laws of the Republic of Trinidad and Tobago contained in the Law Revision Act, Chapter 303, an Act of Parliament number 44 of 1979 specifically says in black and white that the Law Revision Commission shall be constituted. Here's section 16. In the preparation of the laws for any revision under section 8 or 9, the Commission shall have the following powers. A, to omit, Roman 1, all written laws or parts of written laws which have been repealed expressly or by necessary implication, or which have expired or have become spent or have had their effect. This is the black and white laws of the Republic of Trinidad and Tobago. The Honorable Leader of the Opposition was an Attorney General of Trinidad and Tobago, was a Minister of Legal Affairs. The Minister of Legal Affairs has responsibility in the old days for the Law Revision Commission. Prakash Ramadhar, then, I'm calling the name because of the title, the Honourable Member for St. Augustine, was the Minister of Legal Affairs and had responsibility for the Law Revision Commission in 2010. The Leader of the Opposition was the Prime Minister of Trinidad and Tobago, who saw it fit to bestow silk in 2013 upon a select few. And the Leader of the Opposition comes to the Parliament and says, the Law Revision Commission can't revise the laws. Madam Speaker, it gets worse. In a media release, omissions and alterations of the revised laws published by the Secretary to the Law Revision Commission, the Law Revision Commission has stated in black and white that unfortunately they did not amend laws arising out of the case of Gilbert Evelyn and the Attorney General. It was an unreported judgment where Senator Ramdeen appeared as one of the learned attorneys in that case. And the Law Revision Commission put out in black and white, unfortunately this was not done, and the failure to do so was a grave oversight on the part of the Commission. But worse yet, that is in reference to the laws in 2010, 11, 12, 13, 14, and 15, where the People's Partnership UNC government had the public purse and expenditure for the Law Revision Commission. So when the odium is poured, aha, worst government ever, we heard the Honourable Member for Siparia say, perhaps the Honourable Member was referring to the government that occupied office in the period 2010 to 2020. So, Madam Speaker, let me deal with the arguments coming out of Oropouche East. Not a duck and run submission by Oropouche East. Started off in his usual comedy, laughing at himself yet again. I am yet to understand what is so funny in the content that Oropouche East talks about. I just don't get it, Madam Speaker. I try hard to listen, but I find no comedy in any of the subject matter. Laughing constantly. So here we go. Oropouche East says, in his contribution, and he quotes, says he was waiting for Laventille West to get to paragraph 39 of the judgment. Well, let's deal with the judgment. The judgment of the Court of Appeal of the Republic of Trinidad and Tobago, the Supreme Court of Trinidad and Tobago, which dealt with this matter, if I could find it here, very clearly on the 31st of January 2017, the Court of Appeal judgment, I want to put into the record certain parts not traversed by my learned colleague for Laventille West. Summary of decision. The appeal that is against the finding of unconstitutionality in the provisions of section 67 and 68 of the Criminal Procedure Act. Hear this. Paragraph 15. The appeal is allowed for reasons given at paragraphs 31 to 41 below. The cross appeal is also allowed for reasons given at paragraph 25 to 30 below. But listen to this. Relevant evidence, paragraph 16. The facts as stated are compiled from 3 affidavits filed in these proceedings. Here who gave the affidavits? The appellant, that's Jason Bissessa, Mr. Gerald Ramdeen, his attorney at law, and Dr. Anton Cumberbatch. Let me repeat that. The evidence which the Court of Appeal considered in reversing the decision which Siparia sought to bring to the Parliament as an aha, I catch you negligent point, the evidence was given by the appellant, Gerald Ramdeen, and Dr. Anton Cumberbatch. Now, why do I say that? Because Gerald Ramdeen now serves as a senator and participated in the Special Select Committee. Dr. Anton Cumberbatch, now Professor Anton Cumberbatch of the University of the West Indies, appeared before the Select Committee. But, Madam Speaker, listen to this. In the verbatim record of the Special Select Committee, because you know we did a Special Select Committee. Thank God, the verbatim record records everything, Madam Speaker, everything. Here it is. Verbatim notes of the second meeting, Friday, June 16, 2017, at 1:10 p.m. And listen to what we have here. Appearing at pages 28 to 29. Listen to this. I'm quoting now from the verbatim record from Senator Ramdeen's contribution. A person who suffers an abnormality of mind is not and is different from someone who is guilty but insane. Because a guilty but insane person has no culpability, and therefore the only reason that you are detaining that person is for the purposes of ensuring that the person is not a risk to society. So that is why, when we had the discussion in Parliament, you go back to the case of Hadfield, somebody who is guilty but insane, you cannot detain that person for any other reason than for public policy considerations and protecting himself and protecting society. Why have I raised this? Because we squarely considered guilty but insane in the context of Section 67 and 68 of the Criminal Procedure Act. It isn't an omission on our part. The only omission that occurred is the leader of the opposition, Oropouche East and St. Augustine, can't talk to Senator Ramdeen, who gave evidence in the matter, appeared as an attorney at law, participated in the Special Select Committee, and then we have to hear about self-righteousness on the part of the government. Don't tell us what to do, don't tell us what to say. Most respectfully, you know what is infradig? Infradig is, as the Honourable Prime Minister often says, putting up a straw man to beat him down. That's what this is. This is a straw man to beat him down. So let's take the argument of the leader of the opposition. Now recasted 3 versions over when they realized, oh my God, the thing appealed and struck down. First of all, I've checked the Privy Council website. There is no appeal pending right now on this matter. Secondly, even if there is an application for conditional leave, and let's assume that there's one, let's give the benefit of the doubt. The leader of the opposition is saying, we can't support this law because you can't amend the law, and also you ought to change the law. And then the members opposite say, well, hold on. Don't change the law. Leave it as it is. Because the court decision is still outstanding. It's under appeal. Caroni East said it. Oropouche East said it. So which is it? So number one, don't amend the law. The fact is the Court of Appeal has upheld the constitutionality of Section 67 and 68. That's the highest appellate court in Trinidad and Tobago in our local jurisdiction. Therefore, we are bound to accept that the law as expressed is in fact part of the body of laws of Trinidad and Tobago. So the whole submission that you are amending law that was struck down, out the door. Shamefully so. Secondly, leave it as it is. Well, if the argument is leave it as it is because you're going to the Privy Council, then what you raise the point for? What did you raise the point for? The Honourable Leader of the Opposition confused herself all how, as did Oropouche East, saying you can't confuse president with court, and under the Offences Against the Persons Act, you had to change president to court, and look, you need to do the same thing here. The judgment of Mr. Justice Bureau of Appeal, supported unanimously by Mr. Justice Mendonça and Mr. Justice Narain, says in pellucid language that this case is distinguishable from the Offences Against the Persons Act point. And if the honourable members could actually read a case for once from cover to cover, they would have seen that. And what does the court say? The Court of Appeal says that the utilization of the executive authority of the president is appropriate because the president has the obligation to do the review by way of request. And the Honorable Court of Appeal goes further to say that that is supported by implication and by operation of law by applying the rules of common law. Correct. But Oropouche East then says, well, look, they get damages in a case. And then he paused to laugh again at himself. And they get $100,000 in a case. And what happened next? The honorable member again embarrassingly confused himself because the order for damages was offered in circumstances where the state failed to take a step. Look, it's no different from the order in damages in 2 cases brought by Anand Ram Logan against his work that he did as Attorney General, where they had failed to operationalize or provide child rehabilitation centers, and damages were awarded. Exactly the same person who, when as Attorney General, proclaimed the laws to deal with the Forms for the Proceeds of Crime Act, then sued for no forms for the Proceeds of Crime Act and got damages on that. But the determination is also similar to recent rulings of the Honorable Mr. Justice Frank C. Prasad, who came forward to say that in freedom of information requests, that the government had done its very best, this government, to produce Interception of Communication Act reports for 2013, 14, 15, all of them which the last government didn't do. And when they went back to court to ask for 2012 to be produced, the Honorable Judge said, but hold on, for a whole 5 years you didn't do anything. You are the government ministers, now in court as litigants. I'm going to give time for this to be done. So the judiciary does have a common sense approach to matters. Madam Speaker, it is no different from the judiciary also saying and pouring scorn, you would have seen it in today's newspapers, again Justice C. Prasad, saying that the abject failure of the government, UNC government, to have defense council meetings 2010, 2011, 2012, 2013, 2014, 2015, which caused people to go to court and ask for damages, that was a dereliction of duty of the last government. Wow. And apply that to the circumstances of the Court of Appeal judgment now, lay it on to the Court of Appeal saying your common law right of review being exercised properly by the President of the Republic of Trinidad and Tobago. All that you actually have to do is to do the work. And I commend the Minister of National Security for making sure that the Defense Council actually sits. And the Office of the Attorney General is in there tidying up all of the 5-6 years of matters.
48.1, what is the relevance of that?
Attorney General, please continue.
Thank you. So, Madam Speaker, Oropouche East just can't get it right. Now I understand maybe what the laughter is about on his own statements. Because he's comparing apples with watermelons, the honourable member. Secondly, oh my gosh, please, honourable members opposite, lend your leader a hand now. Check a case. Madam Speaker, the Parliament of Trinidad and Tobago, we have Wi-Fi. You could pull up the case on the Court of Appeals listing in the High Court right here, just as we did. As the honourable leader raised the point, we pulled up the judgment right here and looked at it. And I find it incredible that a whole office of the leader of the opposition is at work. Because what are they doing with the Parliament's money that pays the salaries for research? So, Madam Speaker, let's move to the next point, data. Honourable members are saying, well, bring data. Have more discussions. Did you consult? Let's deal with the consultation point. On the consultation point, I can tell you, Madam Speaker, that we received written contributions from the judiciary, December 21st, 2016, from the Criminal Justice Advisor for the UK and Canadian governments, from Mr. Ravi Rajkumar, member of the Criminal Justice Bar Association, and from Mr. Rajiv Prasad, also member of the Criminal Justice Bar Association. And I will say now on the record, all of the advocacy against juries is misplaced, against judge-only trials is misplaced. Because as the honourable member for Port of Spain, North St. Anne's West put it, We are merely providing an amplified opportunity for an election if you so choose. So if St. Augustine has a problem, you don't have to elect. But I'll tell you this, in answer to the question of who will use the system, Madam Speaker, we didn't just come up with a suite of laws, you know. If you traverse the Chief Justice of the Republic of Trinidad and Tobago, back-to-back Chief Justices, and you look at what they've been crying for, hear what they've been crying for. Plea bargaining, abolition of preliminary inquiries, decriminalization of motor vehicle offenses and putting them down to road traffic violations, dealing with an experiment for judge only, dealing with criminal proceedings rules, asking for new courts, asking for improved conditions for the DPP's office, asking for a separate division of the Children and Family Division Court, asking for protocols, asking for judicial autonomy. You know what? We did all of them. All. And we are operationalizing as we speak. And Madam Speaker, I can tell you confidently that the Judicial Sector Committee, we've gone to work further, you know. We're dealing with the prosecutorial arm of the state, which is 95% vested in the Trinidad and Tobago Police Service. We're creating a national prosecutions agency just by way of convention. We don't need law to do it. The Honourable Member for Naparima saying the backlog still high, but at least we know what the backlog is. First Attorney General and first government in this country to tell this population what we are, who we are, and what we're doing about it. You see, solutions don't come out of the air. We had a Ministry of Justice. We had 4 Ministers of Justice. Emmanuel George, Prakash Ramadhar, Chrislyn Moore, Herbert Volney. They produced Section 34. We got the DNA not operationalized. Minister of National Security doing it. We got judicial centers had to break down because the procurement was wrong. But what else did we get? Electronic monitoring not operationalized. Minister of National Security in tandem with his colleagues working on that. Video conferencing at the remand yard, not done. We are dealing with that. Video conference suite recording, we have put that into effect. You see, Madam Speaker, honourable members could come with the cut and paste strategy time and time again. Consult some more, think some more, we don't like this, it's unconstitutional, aha, you're not doing your job. I can confidently say that we have done our job. But let me tell you one thing. I heard the Honourable Member of the Siparia talking about Trinidad and Tobago being blacklisted. I want to know about Trinidad and Tobago being blacklisted. Madam Speaker, my God Almighty, again I pray for Honourable Members opposite to lend the leader a hand. You know what the Honourable Leader was talking about? You know the publication that came out is? Trinidad and Tobago has not advanced in its position on the global forum. You know what the Global Forum is? In 2011, the UNC Cabinet agreed to join the Global Forum. They agreed to common reporting standards. 2011, there was a peer review. There were 2 peer reviews which identified what needed to be done. Minister Larry Hawaii, Minister of Finance, found himself in Berlin in 2014. Take a nice trip in October 28th and 29th. To go and commit that Trinidad and Tobago is on track. 2011, 2012, 2013, 2014, 2015. We were supposed to sign 13 unilateral, bilateral agreements with countries for automatic exchange of information, like we did with FATCA for the United States. The Honourable Leader confusing it, calling it FATCA today, had nothing to do with FATCA, it's Global Forum. They joined us in it. They didn't negotiate a single bilateral agreement, not a single one. It took this Minister of Finance in September 2015 to hustle up and the Attorney General's office to find ourselves on an application for fast track where we applied for a multilateral convention joining so we could join the other 142 countries and achieve the multilateral status, so at least we have agreements. We then drafted the law. We went to Paris. We sent a team of technocrats to Paris for fast track review in February 2017. And then we said to the Global Forum, listen, we would like you to consider our application. They say, hold on, the review is for the period 2010 to 2015. And you know what the country did? Nothing. So Siparia comes shamelessly, not an ounce of research, nobody opposite helping her. Having not done the job for the review period under her own government to complain we blacklisted for FATCA. Getting that wrong too. Oh my gosh, Madam Speaker, when does shame run out? I mean, this is no joking matter, Madam Speaker. We're in the Parliament of the Republic of Trinidad and Tobago, where a leader of an opposition stands up to make a contribution, and nothing that the leader says can be relied on. Nothing, most respectfully. And I don't mean to be pejorative. You'll notice that I've taken a very careful slant and tone. But Madam Speaker, my gosh, it is just embarrassing. So, Madam Speaker, we intend to treat with the Global Forum. We have legislation. Yes, Madam Speaker.
Now 30 minutes are now spent. You're entitled to 15 more minutes.
Should it please you?
Yes.
I thank the army of researchers comprising the body of one in the Minister of Finance. Madam Speaker, with your leave, I wish to quote from the OECD. The OECD said, applying the objective criteria and taking into account the fast-track reviews, Trinidad and Tobago has been identified as the only jurisdiction which has not yet made sufficient progress towards satisfactory implementation of the tax transparency standards. Hear this. Discussions are continuing with Trinidad and Tobago, and progress is anticipated soon. So can you rely on a scintilla of evidence coming from the opposition? Most respectfully, no. 5 years of no compliance. Leave out the germane line, because, Madam Speaker, when you come to the Parliament as a leader of an opposition and you tell the country, your country has been, hear the word, not grey-listed, not negatively reflected upon, your country has been blacklisted for FATCA, not even Global Forum. What do you expect the banking and investment community to do? What do you honestly respect? How can we expect a non-reaction? This is no different from flood politics, Madam Speaker. And why I use the frame flood politics is where, again, you put up a straw man to beat it down, Madam Speaker. Correct. There's a calculated, how should I say this as parliamentary, there appears to be a calculated agenda to cause a loss of confidence in every institution, including the state of the Republic of Trinidad and Tobago.
Correct.
And reckless, unresearched, irresponsible, shameful comments like those made by the Honourable Leader of the Opposition as to constitutionality, as to blacklisting, are just not acceptable in a society that respects democracy such as Trinidad and Tobago does and ought to. So, Madam Speaker, I am not really sure. Yeah, the Honourable Leader of the Opposition is reminding me that when Caroni Central makes the plea that the opposition has, that the Honourable Prime Minister, says, forgive me, I was thinking of Siparia because I've been on the case of that point. But when the Honourable Prime Minister says that in acknowledgement that the opposition has a duty to speak, Madam Speaker, they have a duty to speak after preparation, and they also have a duty to speak the truth. And if honourable members were, how should I say, I don't want to say patriotic. If honourable members were as forthright as they ought to be, they would have just simply said, you know, we got it wrong. We didn't realize the case was overturned. We're sorry about the position. Let's just move on. We heard the move on statement from Siparia many times before. Let's just move on. So, Madam Speaker, that deals with Caroni Central. That deals with the very little that Oropouche had to say. I heard Caroni East talking about the United States of America. There's no comparison between Trinidad and Tobago and the United States of America. Our Constitution does not recognize a right to a jury. The U.S. Constitution does. You cannot compare jurisdictions which have entirely different rubrics and constitutional legal systems. I cannot understand the reference point to the United States of America, most respectfully. Madam Speaker, I think that we have pretty much traversed everything. Let me perhaps say that there is no need to amend sections 67 and 68 of the Criminal Procedure Act on any one of the arguments offered, inconsistent as they are, by the members of the opposition. This is good law. This is law which is taking a step in the right direction. It is coupled with operationalization at the same time. The government hasn't come here being ashamed, as Oropouche constantly says. They're talking about the architecture and the sweet. And he said his sweet has now turned bitter. I think the leader of the opposition said that. Sour. You know what? I'll say it again. The architectural, coordinated, appreciative model is the opposite of VUPS, VAPS, and Vibe. And we make no apology for that. So, Madam Speaker, with those submissions on the record, having wrapped up, I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Offences Against the Person Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters, be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Offences Against Persons Act, Chapter 1108, and the Criminal Procedure Act, Chapter 1202, and for related matters.
Attorney General.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the miscellaneous provisions, Trial by Judge Alone Bill 2017, be committed to the Committee of the Whole.
Honourable members, the question is that the miscellaneous provisions, Trial by Judge Alone Bill 2017, be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause.
Yes, ma'am.
Clauses 1 to 5. The question is that clauses 1 to 5 stand part of the bill. The question is that clauses 1 to 5 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 5 now stand part of the bill. Honourable members, the question is that the bill be now reported to the House. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This committee is now adjourned. Attorney General.
Madam Speaker, I wish to report that the Miscellaneous Provisions Trial by Judge Alone Bill 2017 was considered in Committee of the Whole and approved without amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Miscellaneous Provisions Trial by Judge Alone Bill 2017. All in favour say aye. Aye. Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Supreme Court of Judicature Act Chapter 401, the Summary Courts Act Chapter 420, the Offences Against the Person Act Chapter 1108, and the Criminal Procedure Act Chapter 1202, and for related matters, be forthwith read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Supreme Court of Judicature Act Chapter 401, the Summary Courts Act Chapter 420, the Offences Against the Person Act Chapter 1108, and the Criminal Procedure Act Chapter 1202, and for related matters be now read a third time and passed. All in favour say aye. Aye. Any against? I think the ayes have it.
A bill entitled An Act to Amend the Supreme Court of Judicature Act Chapter 401, the Summary Courts Act Chapter 420, the Offences Against Persons Act Chapter 1108, and the Criminal Procedure Act Chapter 1202, and for related matters.
The Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, I beg to move that this House do now adjourn to Friday, the 30th day of June 2017 at 1:30 p.m. That Friday is Private Members' Day, and I will wait for the Chief Whip to indicate what we'll be doing.
Thank you, Leader. Thank you, Madam Chair. On Private Members' Day on Friday, we prepared to debate motion number 1 on our private members' business.
Honourable members, there is one matter that qualifies to be raised on the motion for the adjournment of the House, filed by the member for Caroni Central. I now call upon the member for Caroni Central.
Thank you very much. Thank you very much, Madam Speaker. The matter that I wish to raise, Madam Speaker, is the matter of the Presal Government Primary School. And from my point of view, and from the point of view of the parents and teachers and children who attend that school, work in that school, and prepare their children to go to the school, it is a very important matter. Primary education is for very young children, usually from 5 to 12. And we have 300 of those children at the primary school in Presal. And I think, Madam Speaker, through you, that the Honorable Minister of Education would know that in 2000, one of the Millennium Goals was education for all, meaning primary school education across the world. And I think that he would know as well that in terms of sustainable development goals, that this is an important goal of the 17 goals that have been identified by the United Nations. So that he would also know, Madam Speaker, that education is at the center of a knowledge-driven society. It is the center of an innovation-led society. And the question I would ask the Minister of Education, through you, Madam Speaker, is why would the government not act to prevent the closure of a primary school when all that is required is that a problem be solved? And the problem is not large. So that we have had a situation where the school has been closed over and over again. It was closed again on Tuesday. Why would the Minister of Education not solve the problem? I would simply like the problem to be solved. Because the problem is a sewer problem, which has a very high stench. And from the point of view of the children and the teachers and the parents, the children get sick, some of the teachers get sick, and they are therefore affected by the children's illness as well. Not only are they ill, but when the children come to school. And the parents, when their children come home, it is a problem. And I don't think any parents would want to close a school when it inconveniences them as parents. So what I want to do is to have the Minister of Education help me to find a solution for the problems at the Presal Government School. The problem is the sewer. It has been fixed before. I will not deny that. I made a request of the Honorable Minister, and he did have it fixed during the last vacation, but it has still since broken down on several occasions. And when it breaks down, the stench is severe. I spoke to the Minister in October 2015, not just on the school and its dilapidated state and the problems that we were having, but also on what he would do with the new school that had been started and was partially completed. I spoke to him again on March the 10th, 2016. I spoke to him on June the 3rd, 2016. I wrote letters to him on June the 6th, on June the 28th, on July the 11th. And I wrote one of the letters that I wrote giving him an entire solution. I won't read the letter in its entirety, but I did say to Minister Garcia, the Minister of Education, might I suggest, Minister Garcia, possible solution? One, use the July-August period to construct a prefab building. I did this as principal of UE St. Augustine, and the 3 buildings that are prefab are still on the UWI campus being used. Secondly, address a permanent solution for the sewer and rehabilitate the existing toilets. And thirdly, set a target date for completion of the new Presal Government School. What has happened instead is that although on many occasions the minister gave me the commitment that the school would be started before the fiscal year 2017 would be over, he then came here during the midterm review to indicate, based on questions, he would not answer the questions in the committee at the finance committee stage, but he did answer it to a direct question engaging on the floor, saying that other schools had been identified as priorities, and this was not now a priority and would be left to the next year. So we tried in every way. I did not take a role in this in which I played a political or activist role. I allowed the parents, the teachers, to organize their own arrangements. Madam Speaker, the talking in front of me is disturbing me. I would like to ask.
I would like all members to observe the rule that asks members who are not speaking to listen in silence. It is late. I would not like to have to rise on this matter again. Member for Caroni Central.
The national PTA got involved with the parents. They sent a petition to them, which they also shared with me. I sent this petition to the Minister of Education. It is signed by, I think, 1,000 parents, and the Minister has possession of this petition. As I indicated, I also offered a solution. And the parents have agreed with the solution. That is to say, they simply want the toilet situation fixed permanently, and now they are prepared to move to the community center, which is not too far from the school. They held their graduation there. I was there. Another member of parliament on our side from Couva South was present. And because all the children cannot fit in the community center, we are asking for a prefab building, which will not be a costly exercise, nor will it be a large building. And as I indicated, all the solution can be provided. If the toilet situation is fixed, the sewer situation, that will solve a problem, but the building is a very dilapidated building, and it is possible that things can happen there that can cause accidents to the children, and maybe injury to the children. So if we move the children to the school, to the community center, and we built the prefab building, they will be safe, they will be free. And if we started construction of the school, they will not be inconvenienced, they will not be under threat, they would not have to deal with the sewer problem. And when the school is completed, they can then move into the new school. So this is basically what I am asking. And Madam Speaker, I do not wish to have any confrontation with the Minister of Education. I just want a solution to the problem. I don't want an explanation of what the problem is. I know what the problem is. All the parents know, all the teachers know, all the children know. I want a solution. I don't want an excuse. It doesn't add any value. I want a solution. And I certainly don't want any mama guy on this issue. It involves the lives of children and the convenience of parents and the proper education and facilitation of the teachers providing that education. And therefore, what I want is a solution. As I said, the solution I propose at this point is the community center, move into the community center, a prefab building to supplement, and a restart of construction as soon as is realistically possible of the unfinished school so that it can be explicitly completed. Education often seems like a system, but education is really one school at a time. And if we don't pay attention to one school at a time, we are not going to be able. Time is over?
Yeah, time is up. Minister of Education.
Thank you very much, Madam Speaker. Madam Speaker, I'm very happy to be given the opportunity to rise and respond to the statements and the arguments presented by the member for Caroni Central. Madam Speaker, the first point I wish to make is that this government is committed to the provision of education, and I might say a quality education for all children in Trinidad and Tobago of school age. And we will not shirk that responsibility. Madam Speaker, the problem at Fitzgerald Government Primary School is one that existed a long time ago. In fact, the member for Caroni Central, in his presentation, admitted that this is not a new problem. And the obvious question now is, why wasn't it fixed long ago? Madam Speaker, we have been toying with this problem and doing our best to ensure that our children are not deprived of an education which is their right. The member for Caroni Central cited two major problems or two major concerns of his. One is the problem with the sewer, and the other one is the delay in resumption of the construction of a new school. Let me first deal with the problem with the sewer. Madam Speaker, there is a problem that has been identified, and that problem is a foul scent that seems to be emanating from the sewer. Madam Speaker, officers of the Ministry of Education, accompanied by the experts of EFCL, visited the school on many occasions. And in May 2017, a temporary solution was put in place, which, from all reports that I have received, was working well. However, we continue to hear the complaints from teachers and from parents that the foul scent persists. Madam Speaker, on June 17th and 18th, that weekend, officers of the EFCL visited the school in an effort to solve the problem. And in fact, additional work was done on the sewer lines at the school, and these works included a dye test which showed that there were no leaks in the system. I want to stress, on the weekend, June 17th to 18th, works were done which included a dye test which showed that there were no leaks in the system. Madam Speaker, it is important for me to state that the principal of the school, accompanied by school supervisors and officers of the Ministry of Education and EFCL, also visited the school. And on every occasion, it was reported that there was no evidence of any foul scent. Now, I'm not saying that there's none. All I'm reporting is the principal of the school reported to us that there was no evidence of a foul scent. However, Madam Speaker, I want to give the member for Caroni Central and this House, and in particular the parents and the students and the teachers of the Fitzgerald Government Primary School, that we will do everything possible to ensure that the students are comfortable in those surroundings. And during the July-August vacation period, which is only a matter of 1.5 weeks off, we will again be looking at the problem in an effort to ensure that that problem does not recur. The second problem that has been identified by the member for Caroni Central is the fact that there is a delay in the construction or the resumption of the construction of the school. I have heard the member for Caroni Central, when he was in the company of parents while they were protesting, stated that the school was at 60% completion. I wish to inform this House that from the information I have received from the contractors and from EFCL and from Ministry of Education personnel, the school is at a level of 40% complete.
Would you give witness for 1 minute? I just want to correct that. I said, and it is recorded, that the school was 60% completed as far as I know, but the minister has claimed 40%. Be that as it may, let us address the issue.
Madam Speaker, I just want to say that everyone would know and would accept the fact that we are facing stringent economic conditions. There are a number of schools that are at various stages of completion. What we have decided, because of our limited resources, we had to prioritize. And the 10 schools that we have identified are schools that are in the region of 90 to 95% complete. Fitzgerald Government Primary School is 40% complete. And this is why it was not put on the priority listing. But as I told the member for Caroni Central on many occasions, we will endeavor to ensure that the completion of the school is done, and hopefully it will be placed as work to be done in the new fiscal year. I don't know whether this satisfies him, but from all intents and purposes and from all that he has been saying, that doesn't seem to meet his satisfaction. We can only do what we can with respect to the funds and the resources that are available to us. But I want to assure the member for Caroni Central that we are not neglecting the Caroni, the Fitzgerald Government Primary School, I want to assure the minister, the member for Caroni Central, that we also hold fast to the goals that talk about the right of a child to an education. And we also agree that education is in the forefront of economic development and social development. And this government and this Ministry of Education has, since we have come into office, we have been doing everything possible to ensure that our children are not denied an education. In fact, access to education is one of our clarion calls. And this is why, for 5 consecutive terms, we have been able to open our doors to our students at the beginning of each academic term, so that what happened in the past did not happen. And again, I want to give the assurance that during this year, July-August vacation period, we will do everything to ensure that when school reopens in September, all our children will have an access to an education, including the students of Fitzgerald Government Primary School. Thank you very much.
Honorable members, the question is that this House do now adjourn to Friday, 30th of June 2017 at 1:30 p.m. All in favor say aye. Aye. Any against? The ayes have it. This House now stands adjourned to Friday, 30th of June 2017 at 1:30 p.m.